So Madam Epic listing for
Which year?
2018, my lord.
18 for admission.
Here and some.
May I please, may I? Worship, item number 32 to 36. May I pray for adjournment, my lordship? My seniority out of station. Any other date, lordship?
32 to 36, what matters are these?
Petitioner is seeking appointment, lordship, without being selection.
Who is for the petitioner?
Several councils.
Item number 36, I am there.
No, but you have to take consent of the other side.
Several councils are there.
You have to take consent.
Lordship, I will inform them, lordship.
No, you inform them, then we'll take it up. You inform the councils, get their consent, make a mention. Be around when the matter is called up.
Lordship, lordship.
Yes.
May it pleases your lordship, my lord. My lord, this is application I is for my lord Recruitment. My lord, today they have filed the affidavit in opposition.
Lord, I appear on
Just
behalf
now
of the
I see.
respondent number 6, 7, and 8, my lord.
Any case, my lord,
You are opposing their implement.
My lord.
Why? All right. Anyway, then,
in the event my marks increase, my lord, then one person has to be go out, my lord. In that case, they are, my lord, the necessary party in this present procedure.
My lord,
These are my submissions.
my lord, respondent number 5 is already resigned from service, my lord. One post is already vacant. And so far as the merit list is concerned, my lord,
no, let us see the order. That. What are you challenging in the written?
My lord, here, my lord, we have, my lord, paid for a re-evaluation of my answer script and 5 questions they re-evaluated and another 5 questions they have not. They say that this will create a problem in the event, my lord, that marks given in this respect of another 5 numbers of questions. My lord, our submission is that respondent authority cannot say that the authority has to forward those 5 questions to the experts. Now, so far, 5 questions are concerns, my lord, that they say my marks increase. And in respect of another, my lord, 5 questions, if those marks are given, my lord, then my marks, my lord, goes up to 59, my lord. The IA application, I have stated in para 9.
Yes.
My lord. Para 9, my lord. In the IA application,
Yes. IA.
IA application.
Yes.
Lord, in the event, my lord, I get, my lord,
No, who conducted the examination?
my lord, APDC.
APDCL.
Yes.
What is the post?
My lord, post is for, my lord,
Assistant account.
assistant accounts officer. So, my lord, my contention is that as per their evaluation, my marks increase now, my lord, by 5 marks. And in respect of 5 questions, they have not sent it for expert. My lord.
Who are the experts? Any experts notified?
Not notified, my lord, those who have, my lord, conducted, my lord, put the, my lord, set the question paper. That has to go to them, my lord, whether I should get the marks or not, my lord.
Now, respondent 5, 6, 7, 8, you seek to implicate them as parties.
Yes, my lord. Because one person,
How many petitioners are there?
petitioner is only one, my lord. Petitioner is only one. Now, last cutoff mark was, my lord, 56.25. That on merit, OBC, one OBC candidate, my lord, travel to that my lord, mark and get selected. But if I get this mark 10 marks, my marks will be, my lord, 59, more than the, my lord, cutoff mark. Then the 56.25,
You belong to any category?
no, my lord.
General, unreserved.
General. And this is 56.25 cut off my for general, my lord.
And
my,
who's for the respondent? You are appearing for whom?
I appear for the respondent number 678, my lord.
6, 7, 8.
As per my instruction, my lord, respondent number 5 has already resigned from service, my lord.
Hmm. So you are appointed as assistant accounts
Accounts officer, my lord. And
by through the same selection process.
same selection process, my lord, same selection order.
my lord, here, the lordship in the repetition, annexer 3 is the, my lord, tabulation of marks,
In the event the writ petition is allowed,
my lord. One party will be affected.
who will be that party?
My lord, here, Indrajit Bora. He shall be directly affected because he has to be, my lord,
You have not arrayed Indrajit Bora.
initially I did not, my lord. Oh. No, my lord. Bolen Sundar Das, he is there, my lord.
Mr. Nath,
No.
who's appearing for the APTCL?
For 1 and 2, my friend appears. For 3 and 4, I'm appearing. Lord.
No, who conducted the
Well,
examination is by for whom?
It was conducted by the APGCL, for all the companies, but the posts are for the APGCL generation company. For
Generation company.
for generation.
So is it correct that respondent opposite party number 5 has resigned?
That information, just now I have heard that I don't have. But here, what I find, although this application is for implement, the statement made in the writ petition, the claim has changed in the IA. In the writ petition, he claimed in paragraph 15 that he should get 60.25 marks in total. Now in this IA, he said that he will get 10,
See,
59.
he has challenged the selection process.
Yes.
Now, there are only two alternatives. Either the writ petition is allowed or it is dismissed.
This is correct.
Assuming it is allowed, then he will have a claim over some post.
Correct.
Now, the last person who entered ordinarily,
He's a general category candidate,
uh,
the last general category person, he will be the effective person.
that's right. So that information ordinarily you are required to provide him so that that person is put to notice.
Correct.
Now, but if respondent opposite party number 5 is no longer there, and if that post is vacant,
No, that
then there's no necessity for implementing anybody. You just keep the post vacant
no,
till disposal of the writ petition.
I have a doubt in that because the same petitioner has filed another writ petition challenging the subsequent advertisement issued by the APGCL for appointment to that category of post. There is another subsequent advertisement. This writ petition is of 2019.
Okay, maybe for anything, whatever I am saying is
Logic.
that if this person has resigned
Logic.
or has not joined, then obviously you will have to advertise that post.
Yes. Subsequently, advertisement was issued.
Maybe,
Logic.
but this information has been placed before the court just now.
Logic.
So if you verify it,
I can verify.
then we can direct this post not to be filled up. Your subsequent advertisement will again be subject to outcome of the writ petition so far as this post is concerned.
Well,
Only one post.
Logic. That information I can take.
Unless you say
Logic.
that no, there are other vacancies available which have not been advertised so far.
I'll take that.
You just keep one post vacant.
No, I'll take that instruction and keeping that post, Lordship at this stage, Lordship may not observe because the subsequent advertisement is already issued and process possibly has been already completed.
Then you furnish the name of the last candidate.
I'll take the, I'll provide.
We are trying to make things easier for you.
Correct.
So if there is a post available, you keep one post vacant till disposal of the writ
I'll
petition.
take-
We'll try to finish it off on an early
I'll
date.
take that.
Can you get it by 2 o'clock?
I'll take that instruction. Yes, telephonic instruction by tomorrow.
By 2 o'clock today.
But
It is only for that instructions whether respondent 5 has resigned or not.
Lordship, I may pay for little accommodation because up to one part matter is fixed. after some time, my lord. I'll, in the second half.
We are only asking for that information.
Yes,
That's
yes,
all. If
yes.
you have that information, we can pass an order today instead of deferring the matter again.
Correct.
So
I'll
your,
get the-
your presence may not be necessary. You can depute one of your colleagues.
Lordship.
You give us this information whether this gentleman at opposite party number
Op-
5 has resigned.
Yes, yes.
See, we are only
Rajdeep
we are
Bora
only
has-
trying
Rajdeep Bora
to,
has resigned or not? Lordship.
yes, number one. Number two, assuming he has resigned and his post is again sent up for another fresh selection process.
What is the stage?
Whether any other posts as on date are available or not.
I'll take
If
that.
available, then we need not even bother about the post falling vacant at serial number 5.
I'll take that issue.
If not, we'll have to issue some directions
But I'll take the issue.
at 2 o'clock.
My lordship.
May please the lordship.
Yes,
Uh,
some
Your
instructions were
Lordship.
forthcoming, were required to be placed.
Yes, your lordship, there are other two analogous matter, that is a WPC. And that is also pending, so that may be tagged together, your lordship. And same advertisement is being challenged there.
My lord. Yes,
Why did you not mention it on the earlier date?
Your lordship, I have been appointed just 1.5 months before, and these petitions was taken care by some other set of lawyers, your lordship.
Is that application connected with the same
Yes,
advertisement?
same advertisement. 5479/2021 and 1735.
My lord, may I submit, my lord, one thing. Till the other day, I was submitting that whether this advisory will have a retrospective effect. But after going through that office order that was issued or handed over yesterday, lordship may have a look at that advisory. It says it will apply in case of clerks and substaff. Now, my lord, the sweepers do not come under the category of substaff.
Where is that advisory again?
Page number 7 or page number in the affidavit in opposition, page number 42. This is dated December 23, 2015. The discontinue interview in the recruitment process for the clerical and sub-staff post in public sector banks. Now, if your lordship takes up the recruitment policy of 2016 of Indian Bank.
You're referring to page 42.
Yes, my lord. This is the advisory by the central government. Initially, my argument was whether it will apply retrospectively or not. Now, my lord, after going through the circular, it appears that this doesn't apply at all. It applies to clerical and sub-staff.
Who are sub-staffs?
Yes, my lord. If your lordship takes up that recruitment policy of 2016 handed over by my friend just on the last occasion. Lordship may come to page number 12. Substaff, two types of substaff. One is security guard and other is 4.4.2 other staff, substaff. Housekeeper cum peon is the category. And if your lordship turns to next page, page number 13, lordship will see the job profile of housekeeper cum peon. Upkeeping of branch office premises to stitch, seal, pack currency notes, bundles, carrying documents, vouchers, files to accompany officer, clerk for cash remittance from the bank to outside office and vice versa, attending any other duties assigned by the bank suitable for the post. And my lord, the qualification have passed 10 standard audits equivalent. Now, if your lordship takes up the recruitment policy of 2007 of sweepers, of 2007 of sweepers. There is another policy that was given to your lordship earlier. 2007. recruitment of part-time sweepers, 2007 of Allahabad Bank.
Not here.
My lord, it was given. Anyway, I'm just.
You read it out.
My lord, in that policy, eligibility criteria has been fixed. There will be no stipulation for minimum educational qualification, but the candidate must not have passed class 10 school final. So for sweepers, they cannot pass class 10, but for sub staff, minimum class 10. Now there is another, my lord, I was representing the sweepers. This instruction I did not have initially. And the bank has, by relying on this circular, has deviated from the issue and misdirected everyone, my lord. Primarily, it applies to clerk and substaff. Sweepers do not come under the category of substaff. Sweepers, this is a circular of 2012, and there is a settlement arrived at between the union and the management. Now, upgradation and norms for posting of full-time, part-time sweepers in scale. So, part-time sweepers in 1/3 scale wages will be upgraded to part-time in half scale wages, and accordingly, so one who are initially in 1/3 pay scale, they will be upgraded to half scale or full-time. If your lordship comes to page 8, lordship will see 50% of the total vacancies of peon cum daftari identified by head office in the respective areas on 1st April will be filled up through change of designation from eligible part-time sweepers on half scale wages. So, my lord, half scale wages part-time sweepers on completion of certain period of service will be upgraded to the post of substaff. So, my lord, they have applied one advisory, first of all, which is not applicable, and misdirected everyone, my lord. They have withheld those information. It is only after the 2016 policy, I tried to get my level best to this for this year from other union officials. Well, the sweepers are not in a position to brief correctly. So that 2016 circular or an advisory is for clerical and substaff. Part-time sweepers do not come within the category of substaff. It is on completion of certain period of service, a part-time sweepers can be upgraded to substaff, and 50% of those vacancies will be filled up by them.
Will you, perhaps it's better to bring it on record. This, let them have an
Because-
opportunity to respond if they want.
And why I'm saying, my lord, they are
By
very much
this-
aware.
By this circular, you are making it very clear that the policy does not apply to
Yes.
sweepers at all. So therefore, this question of waiting for further advisory from the government is irrelevant.
Yes,
Especially
and they
for-
knew it very well from the very beginning. Lordship, for a moment, come to their affidavit, page 45. That is the resolution of the board. They knew it very well. But to exploit these people, they have kept this matter pending for all these years. Lordship may come to page 45
45.
of their affidavit in opposition. Proposal for amendment of recruitment policy, that is the agenda. Discontinuation of interviews in recruitment process for clerical and subordinate staff. Now, my lord, what was
Excluding.
resolved? Approval is accorded for amending the selection criteria by discontinue the interview process for recruitment in clerical cadre and subordinate staff, excluding sweepers. And a proficiency test along with the written test to be conducted for recruitment of armed guard and peon cum driver. Also resolved that till receipt of clarification, permission from so-and-so the processor. So they have added this to exploit them, my lord. It is known to them. Allahabad Bank entered into an agreement with the union to that effect that substaff sweepers, part-time sweepers on completion of certain period of service will be upgraded to substaff. So, my lord, that advisory doesn't apply to them. So they have kept this matter pending. They have utilized their service. They're still utilizing their services on casual basis without completing the process of recruitment initiated in 2014. And this application of this advisory, my lord, is nothing but to mislead everyone, my lord. And in that process, they have not only succeeded in keeping these people out of regular employment for a period of almost 7-8 years, but they are still continuing, my lord. And in the affidavit, they had taken a stand that they had abandoned or kept in abeyance the entire process by suppressing the fact that interviews were already over when the circular or advisory was issued. My lord, these officers are filing affidavits, suppressing facts, misleading everyone, my lord. And the petitioners before a lordship are sweepers,
Therefore, bring it on record, we'll take them to task
my lord.
if we find it.
Lordship will keep this matter on next to any time next week, my lord, next Thursday. I'll by
You
Monday-
bring it on record,
Yes,
you-
I'll definitely file an affidavit.
bring it on record. Heard learned counsels for the parties, Mr. S. Chakraborty, learned counsel appearing for the petitioner, has placed before the court certain documents, including circular dated 1/2/2012, as well as a settlement arrived at by and between the bank officials and the union,
My lord,
which had taken up the cause of the sweepers. And the settlement was signed on 24th of January 2012. Stop, Mr. Chakraborty, placing reliance on these documents, submits that the stand of the bank to say that the advisory
dated 23rd of December 2015.
dated 22nd December 2015, whereby recommendation was made for discontinuation of interviews in the recruitment process in public sector banks for junior level posts by the deadline of 31/12/2015 is not at all applicable in the case of the sweepers. Stop. The said notification clearly reveals that clerical, the said notification is for clerical and sub staff. Stop. Mr. Chakraborty, referring to the recruitment policy of the bank, submits that the sub staff does not include the sweepers. Stop. Under such circumstances, he submits that the inaction of the bank authorities in completing the recruitment process is nothing short of an attempt to continue exploitation of persons who are of persons employed as sweepers on daily wage basis,
Daily
daily wage
Daily
basis
wage.
for the past several years. Stop. This such actions of the board in engaging sweepers on a daily wage basis is contrary to the recruitment policies as well as the circulars issued by the government, as well as opposed to the provisions of the Constitution, which prohibits exploitation of human resource without framing proper policies. Stop. Mr. Chakraborty, Pera, Mr. Sharma submits that these documents which are brought on record, which are being placed before the court, ought to be brought on record by way of an affidavit. Mr. Chakraborty submits that he be permitted.
Next 14th, in the meantime, I'll file the affidavit.
The matter be listed on the 14th of year. let it be, without data review. We'll have it on 19th. You file your affidavit, and if you want, you can file a reply there too.
Yes.
We'll bring these documents on record by way of an affidavit, and the bank authorities will be at liberty to file a response to the said affidavit if so advised. In the meantime, list again on 19th.
And your lordship, other two WP.
It is further submitted by Mr. Sharma that similar writ petitions are challenging the same selection process are pending. And Allahabad Bank,
Yes, it is Allahabad. In one, Amarjit Kapoor versus Indian Bank, and in one is Hemchandra Bharat versus.
similar matters are pending, and therefore he submits that these matters also be listed
Number.
along with WPC, along with the present writ petition. Accordingly, taking on record the submission made by the learned standing counsel for the Allahabad Bank,
Indian Bank. Your lordship.
Indian Bank, list this matter along with WPC or list
5479 of
WPC
2021,
for
5479 of 2021
5479
of 2021
21 and
and 1735 of 2020.
1735 of
2020, your lord.
2020
Yes, sir.
be listed along with
Pertaining
the
to
present
same
writ petition.
Same
advertisement of 2014.
Lordship, in earlier occasion, also the petitioner was not present was.
Right, we'll pass it over for some time. Council on to scroll right. Pass it over for some time. Yes,
There are two issues involved in this case. First, what should be the effective date of petitioner's absorption? And second, counting of the past services in an equivalent post for the purpose of seniority. These are the two fundamental issues.
now pleadings are complete.
Readings are complete.
Okay.
Now, Lordship may see I have the list of dates because there is a background and the circumstances in which, pursuant to a cabinet decision, order of absorption was issued.
These are employees working in PNRD. Sorry, what is that? Where were they working?
He was working in irrigation department,
Irrigation. Okay.
sent on deputation to Panchayat and Rural Development Department. And it was in the Panchayat and Rural Development Department that he was absorbed. So since, my lord, the readings are complete and case is otherwise ready for hearing, subject to my lord's convenience, I may begin today or some other day.
It is up to the councils if you want to.
If they are ready, then I have no difficulty. You may have it.
Yes.
My lord, I will refer to the relevant dates only. The second date is relevant, 15/11/1997. The service of the petitioner was regularized retrospectively with effect from 26 to 96 in the post of Agriculture Extension Officer in the Irrigation Department as per recommendation of APSC. This lordship may see first, page 45, capital A. Because, my lord, most of the documents were not legible, so maximum typing has been done. 45, capital A,
Yes.
the second portion. The notification number IGNE 230, capital A, the second notification.
Hmm.
In supersession of this department notification number such and such,
the services of Sri Soiful Alam appointed as Agriculture Extension Officer under Regulation 3F of the APSC Limitation of Function Regulation 1951, while this department notification number such and such are hereby regularized with effect from 26 to 96 as per recommendation of APSC white such and such. In this department file such and such and in the interest of public service posted temporarily until further orders in the office of Upper Assam such and such such and such. So my lord, his services were regularized retrospectively with effect from 26 to 96 in the irrigation department as Agriculture Extension Officer. Initially, he was a Regulation 3F appointee, that is true. Now, the second is, my lord, he was sent on deputation. That is 4/2/99 is the second date, page 46, may kindly be seen. The Governor of Assam is pleased to place the services of Soiful Alam, Agriculture Extension Officer of this department, at the disposal of Panchayat and Rural Development Department as APO Agriculture. So on deputation, he was sent to the post of APO Agriculture in the Panchayat and Rural Development Department. In DRDO on deputation, finally, initially for a period of 1 year. So that is it. Pursuant to this, my lord, the order, my lord, will find at page 49, annexure 3. That is 25/2/99. On his services being placed at the disposal of this department by the irrigation department, while their notification number such and such, 4th February 99, Sri Soiful Alam Agriculture Extension Officer is appointed as Assistant Project Officer Agriculture on deputation in his great pay and allowances as admissible and posted to District Rural Development Agency Golaghat against the existing vacancy with effect from the date of taking over charge. Now, my lord, charge he took on 13th of March 99, and this is the relevant date. 13th of March 99, he took charge. The date I have mentioned in my list of dates.
Okay.
And this will be relevant, my lord, for this case, in view of what transpired later on.
What was the order on 4th of February?
The 4th of February, my lord, he was sent on deputation, order sending him on deputation.
For 1 year.
25th of February, the order, formal order of appointment on deputation for a period of 1 year.
No.
Now, my lord, he was sent on deputation to an equivalent post. It is, this fact is not disputed that the post of APO, that is Assistant Project Officer Agriculture in the Department of Panchayat and Rural Development, is equivalent to the post of Agriculture Extension Officer in the irrigation department.
Yes.
So 13/3/99 is the relevant date on which he joined in the post of Assistant Project Officer Agriculture in PRD department. Again, this date there is no dispute. Then comes, my lord, the next date after 2 years, 25/9/2001. The next page. My lord, the printing is on the both sides of the page. 25/9/2001. Communication from PRD department to the irrigation department seeking NOC for permanent absorption of the petitioner as Senior Block Development Officer under PRD department. So communication was sent, page 55 of the paper book.
Yes.
My lord has got it. Yes, I'm directed to say that Sri Soiful Alam Agriculture Extension Officer, Irrigation Department, who's working as Assistant Project Officer Agriculture under Panchayat and Rural Development Department, has completed 2.5 years of service on deputation. Now this department is considering for permanent absorption in the post of Senior Block Development Officer under Panchayat and Rural Development Department. You are therefore requested to furnish your no objection certificate on this matter. So they asked for NOC because they were considering his absorption. The NOC came in the next date, which is 29/9/2001. Page 57 is the NOC. Inviting reference to the subject cited above, I am directed to say that Irrigation Department have no objection in the matter of permanent absorption of services of Sri Soiful Alam, Agriculture Extension Officer of this department, such and such, in the post of Senior Block Development Officer. So NOC was issued by the Irrigation Department on 29 September 2001. Now, my lord, nothing happened. 4 more years passed by, and on 27th of January 2005, order is issued. He was repatriated to the Irrigation Department. that is 27/1/2005, 4 years later. Annexure 7, page 58. I'll skip it, not very relevant, is the usual order of repatriation. Then he moves a writ petition, that is WPC 1109 of 2005, and gets an interim order. The order of repatriation is stayed. I'll skip this also. Then comes the final order, that is on 23/8/2010. All these years, on the strength of stay, he was continuing on deputation. 23/8/2010, the order is passed, final order. This I will read, page 64 and 65.
Yes.
From second para, I'll begin, my lord, page 64.
Yes.
This writ petition has been filed making a grievance against Annexure 6, order dated 27/1/2005, by which the service of the petitioner was placed at the disposal of Agriculture / Irrigation Department with immediate effect. The petitioner, who was sent on deputation to the Panchayat and Rural Development Department from the Irrigation Department by Annexure 1 order dated 4/2/99, was repatriated to the parent department by the said order, that is 27/1/2005. According to the petitioner, since he has continued for a fairly long period of time in the borrowing department, he is required to be absorbed in the said department in terms of Annexure 5 of his memorandum dated 19/7/97. It is a further case of the petitioner that the impugned order dated 27/1/2005 was issued only to accede to the request of the particular MLA who had addressed Annexure 7 letter dated 20th January 2005 to the Minister of Panchayat and Rural Development Department, by which a request was made to repatriate the petitioner to the parent department from the borrowing department. As a deputationist, the petitioner has got only a limited right. Irrespective of any policy decision, he cannot claim that having continued for few years, he must be absorbed in the borrowing department. Such and such as Standing Council BTC has produced the copy of the order dated 2/5/2007 passed by this court in WPC such and such, in which under similar circumstances and noticing the aforesaid office memorandum dated 19/7/97, it has been held that a deputationist cannot continue in the borrowing department, and that on the strength of the said office memorandum cannot also claim absorption in the borrowing department. However, and this is relevant, my lord, because it was on the strength of these lines that he continued. However, it was provided in the order that it will be open for the petitioner to file application for regular absorption in the borrowing department. Considering the matter in its entirety, this petition is disposed of in terms of the said order dated 2/5/2007 passed in WPC such and such. Interim order passed on 23rd February 2005 stands vacated. So, my lord, that liberty was given, that option was given, that he could file an application for regular absorption, and the department will consider it. So, my lord, on 14th November 2011, he files an application for his absorption in the borrowing department. Till then, he continued. And then lordship will see that there are series of dates. The entire exercise was undertaken for the consideration of the cabinet. This is important. The proposal for the consideration of the cabinet.
Yes. Page number?
Page 68 to 69, capital A.
Yes.
The cabinet memorandum. This I'll read, my lord, in extenso. Permanent absorption. My lord has got it? Yes. Permanent absorption.
This is the proposal.
Proposal, yes, my lord, because it
So,
was.
What
as my
was
lord
the
knows, cabinet-
decision? What was the decision of the cabinet?
Wrote one word approved. So the proposal was approved by the cabinet. So therefore, my lord, the material that was placed before the cabinet is of relevant consideration. Cabinet approved it. So I'll read, my lord, what exactly was the proposal before the cabinet.
I think the portion from para 7 would be relevant, perhaps.
Very well, my lord. That's true, because till capital B, page 69, narration of the past events in total. it is pertinent to mention that Sofiul Alam is presently an agriculture extension officer under the pay band 4 of rupees 12,000 to rupees 40,000 with grade pay of 54,000 and is working in the capacity of assistant project officer agriculture in DRDA Nagaon in the grade pay of rupees 5,900. At present, there are vacancies having identical pay scale of the post held by Sofiul Alam, assistant project officer, as stated below. A, the post of deputy director training, deputy director panchayat, and deputy director FP with pay scale of such and such, grade pay of 6,300 are lying vacant at the establishment of the Commissioner Panchayat and Rural Development. The post of Deputy Director Panchayat, Deputy Director FP and Deputy Director Training are promotional posts as per Rule 11C, Schedule 2 of the Assam Panchayat and Rural Development Officer Service Rules 2013. With the views and concurrence of the concerned referral departments, while their endorsements depicted above, the Panchayat and Rural Development Department decided to permanently absorb the services of Sofiul Alam, Agriculture Extension Officer, Irrigation Department under deputation as Assistant Project Officer Agri at DRDA with the approval of the Honorable Cabinet. As such, the matter is placed before the Honorable Cabinet for kind approval towards quote-unquote permanent absorption of the services of Sri Sofiul Alam, Agriculture Extension Officer, Irrigation Department under deputation as Assistant Project Officer at DRDA to any vacant equivalent post under the establishment of the Commissioner Panchayat and Rural Development Assam with relaxation of the relevant rules. Then, my lord, comes the cabinet decision, which my lord will find at page 71, annexure 12.
Yes.
Permanent absorption of services of Sri Sofiul Alam, Assistant Project Officer, DRDA HQ Nagaon under the establishment of the Commissioner Panchayat and Rural Development Assam, approved. So this is the cabinet decision. Now, my lord, thereafter, the next relevant page is, my lord, the page 78. Page 78. This is the notification. And catch lies here, my lord. The formal order of absorption and the expression used.
Yes. Yes, please.
78 page number, annexure 14. On his services being placed at the disposal of Panchayat and Rural Development Department by the Irrigation Department, Government of Assam, Sri Sofiul Alam, Assistant Project Officer, Agri DRDA, is hereby permanently absorbed against the vacant sanction post of Deputy Director Training, which was created by such and such, that is 22nd March 57, the post was created, and retained permanently by such and such under the establishment of the Commissioner, Panchayat and Rural Development Department, Assam, in the scale of payment such and such, grade pay 6,300 per month as per ROP 2010, with, and this is important, my lord, with effect from the date of joining in the Panchayat and Rural Development Department. The expression used is, my lord, with effect of the date of joining in the department. The reference is not, it's not qua the post, it is the department. Now, so far as the department is concerned, my lord, the case of the petitioner, look, I came on deputation and I joined on 13th of March 99.
After the order of repatriation, were you sent back?
No, I was not sent back.
You continued.
This is what I understand from the records, whatever has been stated. Was he sent back? He was not sent. He was not sent. Order was stayed, final order issued. After the final order application is filed, in the meantime, he was not sent back. So he continued.
All right.
So it is the department, date of joining. So from there, my lord, ultimately the interpretation is started. What exactly cabinet wanted to convey. Then my lord will find I took charge of the post of Deputy Director on 1st October 2016. That is another date, my lord, and that is important because the story of the other side is the respondent, look, the effective date will be the date on which he took charge. That is 1st of October 2006. Now, my lord, the query. On this very issue, the query was raised by the Office of the Accountant General Assam. That is annexure 15, page 79 to 81. The query is interesting. Page 79. From the Office of the Accountant General. It is addressed to the Chief Secretary, Government of Assam, Panchayat and Rural Development Department. I read, my lord.
Yes.
In inviting a reference to the government notification dated 12/9/2016 and a representation submitted by Sofiqul Alam, Deputy Director Training, dated 4/10/2016. On the subject noted above, I am to state that as per government notification mentioned above, Shri Alam has been permanently absorbed against vacant post of Deputy Director Training in the scale of pay of rupees 12,000 to 40,000, 4 grade pay, rupees 6,300 PB4, payment 4, with effect from the date of joining in Panchayat and Rural Development Department.
This
In
post
pursuance
of
which
this post of deputy director
training.
is equivalent to
My lord, this is what the respondents say from the very beginning.
is equivalent.
Yes. Because so far as the grade pay of 6,300 is concerned, that came by ROP of 2010. But basically the post is equivalent.
Yes.
Accordingly, pay slip such and such, whereas Shri Alam, by his representation, copy enclosed, has stated that he has been permanently absorbed as Deputy Director Training with effect from 30/3/99, the date on which the officer's services have been placed under PRD Department by the Irrigation Department. In view of this, government is requested to let this office know the exact date from which Shri Alam has been absorbed permanently as Deputy Director Training under PRD Department. In the event of absorption with effect from 13/3/99, the following points require clarification. One, the scale of pay to which the officer has been absorbed and the date from which the post is lying vacant. The date from which the post is lying vacant. And my lord, the interesting point here is, my lord will find, once I proceed further, this post was lying vacant with effect from 1st March 99. So the post of Deputy Director Training was vacant all along, effectively from 1st of March 99. Till my lord he joined on 1st October 2016. What would be, the second query is, what would be the treatment of the amount of leave salary contribution paid for the period with effect from 1/12/2002 to 16/9/2003 and from 17/9/2003 to 17/10/2008, amounting to rupees 5751 plus 40,581, that is total 46,332. Likewise, pension contribution deposited for the period with effect from 18/10/2008 to 31/3/2011, amounting to 2,21,772. To this, my lord, my answer will be simply, if there is a balance and amount is required to be paid, petitioner certainly will have to pay that, and he will pay that amount, and balance will be cleared. 3, the name of the officers holding the post of Deputy Director Training under PRD Department with the tenure of office with effect from 13/3/99. In that case, supernumerary post may be created with the concurrence of the Finance Department, Government of Assam, to accommodate Shri Alam as Deputy Director Training with effect from 13/3/99 till the date, that is prior to the date the post is lying vacant.
This
Since
is in
only-
this is in the event number 1 is not available.
Yes, naturally. But then, as my lord will find, the post was lying vacant with effect from 1st March 99. So now, my lord, I will take my lord to the next date is not relevant. The query was forwarded to the Commissioner PRD for answer, and the answer came, my lord, at page 85. The stand was very positive towards the petitioner, but the whole face will come thereafter. Page 85 is the answer of PRD. This I read, page 85, annexure 17. With reference to the subject cited above, I am to furnish the report related to point number 3 contained in the letter of AG Assam, wide number such and such, as follows. The name of officer holding the post of Deputy Director Training under the establishment of Commissariat, Panchayat and Rural Development Assam, with effect from 13/3/99 till 30/9/2016, may kindly be treated as nil, as the earlier incumbent, namely Shri Sam Munir, the then Director Training, was retired on 28th February 1999. Meaning thereby from 1st March 99, the post was vacant from his service. And since then, the post of Deputy Director Training was lying vacant in this commissariat. Hence, the matter of creation of supernumerary posts with effect from 13/3/99 to accommodate Shafiqul Alam, Deputy Director Training of this commissariat does not arise, such and such. So this is a very, very positive stand taken at page 85 by PRD. Then comes my lord again, page 86. The same position was reiterated in another communication at page 86, which is dated 23rd of May 2017 by PRD to the Accountant General. With reference to the subject cited above, I am directed to furnish herewith the required information as sought for pertaining to the matter of permanent absorption of Shafiqul Alam, Assistant Project Officer, DRDA, Nagaon, against the post of Deputy Director Training as follows. In the scale of pay of rupees such and such, with grade pay 6,300, the post was lying vacant since 1st March 99. Leave salary and pension contribution made during the deputation period are mandatory and are to be adjusted. Adjusted, my lord, my submission would be petitioner will have to pay the balance. The post of Deputy Director Training has been lying vacant with effect from 1/3/99, hence furnishing of name of officer holding the said post doesn't arise. This is it. Then, my lord, the more clarifications were sought by Accountant General's office. This, my lord, will find at page 87 on 26th July 2017. Page 87.
Yes,
There is more questions. Page 87.
yes, please.
In inviting a reference to the government letter on subject noted above, I am to request the government to intimate the following points. 1. The exact date of permanent absorption in respect of Shri Alam as Deputy Director Training under PRD department as sought for in second para by this office letter number such and such, dated 22nd February 2017. The scale of pay of rupees 12,000 to 40,000 payment for with grade pay 6,300 against the post lying vacant with effect from 1/3/99 as indicated while government letter under reference is ambiguous since pay band and grade pay system was introduced under ROP 2010 with effect from 1/1/2006. The mode of fixation of pay in case of permanent absorption of Shri Alam in Panchayat and Rural Development Department Assam, the mode of fixation of pay. So these were the questions asked in page 87. Thereafter, my lord, the series of representations by the petitioner, I'll skip all that. Now, my lord, the problem begins from page 90. The stand is reversed by PRD. The reversal of the stand can be seen at page 90. The UO note of Joint Secretary, 29th of August 2017. Page
Yes.
90. Now the reversal. Order at page such and such is all you know. This is regarding regular absorption of the service of Shri Shafiqul Alam with an agriculture extension officer, irrigation department, who was initially placed at the disposal of the Panchayat and Rural Development Department on deputation, white notification number such and such dated 4/2/99 by irrigation department, government of Assam, and accordingly he was posted as state project officer such and such. It is also pertinent to mention that white notification dated 27/1/2005, PRD department placed the service of Shri Shafiqul Alam, assistant project officer, at the disposal of irrigation department, for which he approached the Honorable High Court. All that narration is there. Then comes the last paragraph in this page. Having served under PRD department for more than 17 years, and in the light of Honorable High Court's order dated 23/8/2010, the service of Shri Shafiqul Alam, APO Agriculture, DRDA, Nagaon, has been permanently absorbed against the vacant sanction post of Deputy Director Training, Office of Commissioner, PRD, Assam, with effect from the date of his joining in PRD department by government notification dated such and such with the approval of the state cabinet. So narration of fact. However, Office of the Accountant General, Assam, has now sought clarification pertaining to his exact date of a permanent absorption for taking further necessary action from their end. In the department order dated 12/9/2015, he was permanently absorbed with effect from joining in the PRD department. And as per this, his date of joining in PRD department on deputation in DRDA Golaghat is 13/3/99. Hence, now on the queries of AG Assam, such and such, PRD department has opined that his date, so my lord, then here they are talking about the opinion that has come from the PRD. Hence, now on the queries of AG Assam, PRD department is opined that his date of absorption will be the date of joining as Deputy Director Training in PRD department, that is 1/10/2016. So the Joint Secretary gives a note and then says, now the reversal, this is what it is all about. My lord will see the apparent, my lord, contradiction in the two things. In the preceding paragraph, the stand taken is, since the order of absorption uses the expression department with effect from date of joining in the department, therefore the date should be 13/3/99. But then say now the opinion of the PRD is that it should be with effect from 1/10/2016. Then, my lord, various things. Finally, my lord will see the note of Joint Secretary PRD seeking the views of finance at page 94 and 95. 1st of December 2017.
Yes.
My lord, practically, my lord, the same language. Same language, 94 and 95. It is Joint Secretary referring to finance. Practically the same language, page 94, last two paragraphs.
Yes.
94, last two paragraphs. In the departmental order dated 12/9/2016, he was said to be permanently absorbed with effect from the date of joining in PRD department. And as per this, his date of joining in PRD department on deputation Golaghat is 13/3/99. This is a positive stand. Then, but on query of AG Assam, PRD department is opined that his day of absorption will be the date of joining FA. Finance and accounts. Okay, so my lord, it is an opinion of the finance and accounts department of the PRD. Finance and accounts wing. FA PRD has opined that his date of absorption will be the date of joining as deputy director PRD 1/10/2016. So they are unable to decide. They're quoting FA wing of the PRD. But my lord, the catch comes, the finale comes at page 115. The communication, the final communication which was issued by the Principal Secretary PRD. It is 28th of August 2020, page 114 to 115.
Yes, yes.
This is the finale.
Yes, please.
114 is the covering letter, 115 is the substance. This I read, my lord. Addressed to Accountant General by Principal Secretary PRD. In inviting a reference to the letter on the subject cited above, I am directed to inform you that she is Safiul Alam, earlier Agriculture Extension Officer, Irrigation Department, was appointed as Assistant Project Officer Agri on deputation in DRDA, Golaghat, and which was a society post, while government notification number such and such dated 25th February 99. And accordingly, Shri Alam joined as Assistant Project Officer Agri on 12/3/99 at such and such. In the light of Honorable High Court's order dated 2/5/2007, passed in WPC such and such, it has been held that a deputationist cannot continue in the borrowing department, and that on the strength of the said office memorandum cannot also claim absorption in the borrowing department. However, it was provided in the order that it will be open for the petitioner to file application for regular absorption in the borrowing department. In addition to that, as per Honorable High Court's order dated 23/8/2010, passed in WPC such and such, court, as a deputationist, the petitioner has got only a limited right. Irrespective of any policy decision, he cannot claim that having continued for few years, he must be absorbed in the borrowing department, unquote. Moreover, as per observation at point 3, on the letter and the reference, it appears that the post of Deputy Director Training was lying vacant in the office of the Commissioner PRD Assam since 1/3/99 to 39/2016. Hence, creation of supernumerary post doesn't arise. Later on, as per approval of Honorable State Cabinet held on 27/7/2016, the incumbent was permanently absorbed in the vacant sanction post of Deputy Director Training under the establishment of the Commissioner Panchayat and Rural Development of Assam in the scale of pay band such and such, grade pay such and such, with effect from date of joining in the Panchayat and Rural Development Department by government notification number such and such. Accordingly, Shri Alam has joined as Deputy Director Training on 1/10/2016 at such and such after permanent absorption against the sanctioned post. Hence, in any event, the date of absorption of Shri Safiul Alam into PRD department can be only after approval of cabinet held on 27/7/2016. As such, the date of absorption of Shri Alam is 1/10/2016, the date of joining against a permanent post in PRD department. So with this, my lord, it was concluded. Now, my lord, the two issues would arise. If this is the stand taken by PRD, whether, my lord,
On his deputation, what was the post that he joined first?
assistant project
Officer.
officer,
He continued,
agriculture,
he continued in the post
he continued in the post
till the time he was sought to be
Absorbed.
absorbed.
till the time he was absorbed.
All right.
So, my lord, first of all, counting of the past services. And my lord, another aspect for consideration here is not only, my lord, his deputation was also to the equivalent post. The earlier post of agriculture extension officer is equivalent to assistant project officer. Agree. So, my lord, practically from agriculture extension officer to till date, it is practically an equivalent post. This is the stand of the department also. Now, my lord, the first aspect is number one, counting of the past services for the purpose of seniority and the effective date of absorption. My lord, my submission here would be, it is true, my lord, that he joined as Deputy Director Training on 1/10/2016 pursuant to the order of absorption dated 12/9/2016. So, my lord, physically he occupied the post of Deputy Director Training effectively from 1/10/2016. So, my lord, a period prior to that, my lord, he will only get the notional benefit. He will not get, my lord, the pecuniary benefits of that. It is only the notional benefit. So, my lord, for the purpose of notional benefit, that is the seniority. Because in any case, my lord, the proposition, the principal, my lord, is aware of in SI Ruplal case, even if when you are transferred to an equivalent post or deputed to an equivalent post, the services rendered by you in the parent department to an equivalent post is counted towards your seniority. So either way, my lord, the post is to be counted. The period served by him in the equivalent post, either on deputation or below the post in the parent department, will be counted towards the seniority. That is first part. The second part will be he gets only the notional benefit, namely the seniority. For the purpose of counting of pensionable years of service also it is taken into consideration. He won't get wages for that because physically he occupies the post on 1/10/2016. So, my lord, there should be no difficulty whatsoever. And so far as, my lord, the leave salary and contribution towards the pension is concerned, the balance he will have to pay naturally. So, notional benefit of seniority, continuity in service so that there is no break in service, balance he clears it, and that is all. There should be no confusion.
What is the stand of the department?
The stand of the department, my lord, number one is the ambiguity initially very positive. Positive with capital
No,
P.
in their counter.
Counter, my lord, reiteration naturally, my lord, they cannot resign from the communication which is given by Principal Secretary to the Government of Assam to the Accountant General's office. They can't deviate from this stand now. So, my lord has seen there is a contradiction. Initially, the stand is positive with capital P. Thereafter, my lord, the final jolt comes in page 115. A reversal of the stand, lock, stock and barrel, completely. Prior to that, they keep on saying because they are confused. They don't know what to do. The order of absorption by notification says with effect from the date of joining in the department. Had it been the intention of the department that no, his absorption is only against a particular post, so with effect from the date of joining as Deputy Director Training, I would have understood. It is a department. And in any case, my lord, I ask myself, had it been, even if the expression would have been with effect from 1/10/2016, namely the date on which he will take charge as Deputy Director Training, even in that case, the past services would have been counted. The SI Ruplal principle, holding of an equivalent post. The service cannot be wiped out. He is a government servant, an employee of the Government of Assam, serving as a regular officer in irrigation department, came on deputation. Deputation, my lord, not only I am willing, but both the departments also will have to be willing equally, borrowing and the parent. So, my lord, it is consensus from all sides.
So the only question is counting of your seniority.
Yes. And, my lord, the balance, that amount, that may not petitioner will have to pay naturally for the purpose of retirement benefits and also towards the leave salary, etc. So there is no difficulty.
Yes.
So, my lord, SI Ruplal judgment, my lord, is familiar, but even then, 2000 volume 1 SCC. The Supreme Court had an occasion to interpret the central government notification, but since then, my lord, it has evolved as a principle. SI Ruplal. Especially in Arunachal, they keep on referring to it in very many cases. That is 2001 SCC, page 644.
2000.
2000 volume 1 SCC,
Yes.
page 644. The relevant paragraph, my lord, para 17. (19) and 20. Lordship, I'm sorry, I didn't bring the extra copy. Lordship, may have a look.
We'll arrange for a copy. No issues. Yes, you may carry on. Do you have a copy with you?
No, I don't have. That's
So,
why I'm
so
sorry.
you read the relevant paragraph.
I- Para 17 at page 657. In law, it is necessary that if the previous service of a transferred official is to be counted for seniority in the transferred post, then the two posts should be equivalent. That is the first principle Supreme Court emphasizes. One of the objections raised by the respondent in this case, as well as in the earlier case of Anthony Matthew, is that the post of sub-inspector in BSF is not equivalent to the post of sub-inspector executive in the Delhi police. In this case, not from Delhi police, he went to the BSF or vice versa, whatever. This argument is solely based on the fact that the pay scales of the two posts are not equal. Though the original bench of the tribunal rejected this argument of the respondent, which was confirmed at the stage of SLP by the Supreme Court. Which was confirmed at the stage of SLP by this court. This argument found favor with the subsequent bench of the same tribunal whose order is in appeal before us in these cases. Hence, we will proceed to deal with this argument now. Equivalency of two posts is not judged by the sole fact of equal pay. This is relevant, my lord. Equivalency of two posts is not judged by the sole fact of equal pay. While determining the equation of two posts, many factors other than pay will have to be taken into consideration, like the nature of duties, responsibilities, minimum qualification, etc. It is so held by this court as far back as in the year 1968 in the case of Union of India versus P.K. Roy. In the said judgment, this court accepted the factors laid down by the Committee of Chief Secretaries, which was constituted for settling the dispute regarding equation of posts arising out of the States Reorganization Act of 1956. These four factors are: 1, the nature of duties of a post; 2, the responsibilities and powers exercised by the officer holding a post; the extent of territorial or other charge held or responsibilities discharged; 3, the minimum qualifications, if any, prescribed for recruitment to the post; and 4, the salary of the post. It is seen that the salary of a post for the purpose of finding out the equivalency of posts is the last of the criteria. If the earlier three criteria mentioned above are fulfilled, then the fact that the salaries of the two posts are different would not in any way make the post not equivalent. In the instant case, it is not the case of the respondents that the first three criteria mentioned here and above are in any manner different than the two posts concerned. Therefore, it should be held that the view taken by the tribunal in the impugned order that the two posts of sub-inspector in BSF and sub-inspector executive in the Delhi police are not equivalent merely on the ground that the two posts did not carry the same scale of pay is necessarily to be rejected. We are further supported in this view of ours by another judgment of this court in the case of Vice Chancellor Ellen Mithila University versus Dayanand Jha, wherein at SEC para 8 of the judgment, the same principle has been relied on by the Supreme Court. Then comes the paragraph 19. This leaves us to consider the validity of the office memorandum which was relied upon by the tribunal in the interim judgment. We have noticed earlier in the judgment that the constitutional validity of this memorandum is independently challenged by the appellants in WPC number 191 of 99. There is considerable force in the argument addressed on behalf of the appellants that this memorandum had neither been made public nor the existence thereof made known to anybody concerned with the controversy in question. We have already referred to this fact. Hence, we do not want to repeat the same in detail. On facts, we are of the opinion that the respondents ought not to have been permitted to rely upon this document because there is no material whatsoever produced by the respondents to show that this memorandum, which was issued by the government of India, was either ipso facto applicable to the Delhi police force or the same was adopted and applied by the Delhi police force. It is to be noted that the law in regard to the right of a deputationist to count his service for the purpose of seniority in the transfer department was settled as far back as in the year 1982 itself in the case of R.S. Makashi and Wing Commander J. Kumar. So the court says you need not go into the memorandum or contradictory memorandum, etc. The law is settled. We settled this law as far back as R.S. Makashi case and Wing Commander J. Kumar's case. Therefore, it is reasonable to expect that a deputationist, when his services sought to be absorbed in the transfer department, would certainly have expected that his seniority in the parent department would be counted. So, I'm not pausing here, I would submit, not to speak of his period served in deputation, even the period served by him in the parent department as agriculture extension officer, my lord, will have to be counted as the post equivalent.
Yes,
You know, same reiteration. This is what the law is on the subject.
yes.
So, my lord, my submission is there is no difficulty whatsoever. Only the notional benefits. That's all. And the balance for the purpose of pension and the leave salary, my lord, he will have to pay naturally.
Okay.
I hope, I don't know the state.
Roshan may kindly come to our affidavit matter. The relevant paragraph, I'll just read mine. Start from paragraph second, my lord, page 118, running page, my lord.
Hmm.
May I read, my lord? The statement made in so and so, my lord, repetition in matters of records of the case, your deponent does not admit so and so, so and so. It is a fact that Srimati Lalita Devi and S.A. Laskar, dean and sociologist of Municipal Administration Department, were appointed as deputy director, white notification dated so and so, dated 12/9/1997, on deputation against the vacant post of deputy director WC and deputy director SNP, respectively, in the office of director PNRD Assam. Both the incumbents were permanently absorbed in the permanent vacant post of deputy director WC and deputy director SNP, respectively, by government notification dated 27/3/2001, like the petitioner, my lord. In the office of the director so and so. However, the deputation period of Srimati Lalita Devi and S.A. Laskar from 12/9/97 was not considered after permanent absorption. As such, there is no precedence of considering the deputation period as permanent employee of the department. Now, next paragraph, my lord. Fourth line, my lord, relevant person. The services of the petitioner, Sri Safil Alam, the then agricultural extension officer of irrigation department, was borrowed on deputation and appointed as assistant project officer agriculture under DRDA Golaghat on 13/3/1999, white government notification dated so and so, dated 25/2/99. The petitioner was permanently absorbed in the office of the Commissioner PNRD Assam as per approval of the Honorable Cabinet in its meeting held on 27/7/2016 and was permanently absorbed by government notification number so and so, dated 12/9/2016 and from the date of joining 1/10/2016. It is pertinent to mention that by order dated 23/8/2010 in WPC 1109/2005, Safiyul Alam versus so and so, Honorable High Court had clearly mentioned that as a deputationist, the petitioner has got only a limited right. Irrespective of any policy decision, he cannot claim that having continued for a few years, he must be absorbed in the borrowing department. For a
No, that's not
moment,
his case. It's not, his case is not that he wants to be absorbed.
my lord.
You have absorbed him
Yes, my lord, but
in an
all-
equivalent post.
My lord, my lord, for that, my lord, for relevance, some date is very important, my lord. He has joined, my lord, on 13/3/2019. Thereafter, my lord, lordship may kindly come again, page 58 of the petition, my lord, by which, my lord, page 58, his service was released, my lord. He was released, he is replaced at the disposal of Agriculture Department and Irrigation Department again, my lord, which
was
was the
released.
subject matter of the writ petition, earlier writ petition.
Uh,
And white order dated, my lord.
but that order was stayed.
Yes, state. But my lord, that order was interim was vacated on 23/8/2010, my lord. White order dated
Then what
23/8/2010.
happened? He went and joined.
That interim order was vacated.
Oh,
That means,
correct.
my lord, that order was there, my lord. Although he was not rejoined. But order was there, my lord. Thereafter, Honorable High Court, my lord, granted liberty to file application afresh. Thereafter, he filed again application, my lord. And after approval of the cabinet memorandum, my lord, on 2016, he was again finally absorbed, my lord. And lordship may kindly see the prayer of the writ petition, my lord. 38 of the writ petition, my lord. Prayer, my lord. Prayer is that, my lord, to give effect to the permanent absorption of the petitioner in the post of Deputy Director Training from 13/3/99, my lord. It is not disputed that he was joined on deputation in the year 99, my lord. But his final, admittedly, his final date of absorption is 2016 after passing the memorandum, my lord. But he is praying, my lord, that his permanent absorption date shall be treated as 13/3/99, my lord.
Yes.
And that interpretation is the author of that order, my lord, is the best interpreter, my lord. That what is the joining date of the petitioner, my lord. That office memorandum, my lord, after the approval, my lord. After the approval, the order of the absorption, my lord, final absorption, after the date of the joining. Means, my lord, after the date of the joining of the final absorption, my lord.
Yes.
May I read more, my lord, the letter, my lord, the page 120, the letter part, my lord, my form affidavit, my lord. May I read, my lord. Further, the Honorable Court, in its judgment dated 2/7/2007, in the WPC number 620 of 2007, Sri Arun Kumar Brahma versus State of Assam, opined that the deputation of a government servant from one department to another department under the same state of government is not covered by the notification dated so and so, which speaks of deputation of state government employees either to the central government or the other state government or incorporation bodies under the state central government.
Where is that notification?
Notification they have, I think, next, my lord. They have referred, my lord, that for that notification, my lord. But I have. I have a copy of that judgment, my lord, by which the Honorable Court observed, my lord, that notification will not cover the case of the petitioner, my lord.
You're referring to the order.
Yes, my lord.
No, I was asking you for the notification. What does the notification
Relying
say?
on the
My
notification.
lord.
I'm
Yes.
not relying on the notification.
Now
My
he is
case
not,
on principle
petitioner
of
is
law.
not relying, but I'm
I am on the
submitting, my
position
lord.
of law.
As the case of the petitioner is there also, my lord, I am just replying, my lord. Next page, my lord, page 121.
Hmm.
The petitioner, Sri Safiul Alam, was permanently absorbed in the PNRD department, while order entered 12/9/2016, and he joined in the department on 1/10/2016. As such, he became the employee of the department only from the date of joining 1/10/2016, my lord. Now, paragraph number 9, my lord. The fifth line, my lord. The PNRD department had already clarified the date of permanent absorption of the Sri Safiul Alam, the petitioner, my lord, in the PNRD department, which is 1/10/2016 to the office of the Accountant General, my lord, from the letter dated 28/8/2020. Now, last, my lord, paragraph 10, my lord, fourth line. As stated in the contents of the para, PNRD department has clarified, right, so and so dated about the detail of the same, my lord.
May I make one thing very clear for the benefit of my esteemed colleague? I think there is a lack of clarity on my part due to which there is some confusion in understanding. I clarify again and I reiterate, regardless of the date of absorption, I am not saying, it is not my case, that I have to be given the label of Deputy Director Training effectively from March 99. I am not saying that. Physically, I occupied the post of Deputy Director Training on 1st of October 2016. But for the purpose of seniority, my past services rendered both in irrigation as well as in the Panchayat and Rural Development Department as deputationist will have to be counted. That's all. By all means, yes, I'm Deputy Director Training effectively from 1/10/2016. It is a question of counting of seniority of the past services rendered. And I only get the notional benefit of Deputy Director Training and nothing else.
What is the post now that you are
Deputy Director Training
Deputy Director Training?
effectively from 1/10/2016. There is no difficulty about it.
Hmm.
The question is seniority. I do not say that you give me the label of Deputy Director Training effectively from March 99. I don't say that. I only say that I am entitled to the seniority of the past services rendered, both in my parent department as well as a deputationist in
Now-
Panchayat and Rural Development Department.
Now, initially, you were working under DRDA.
Not yes, but it
You
is
are
under
deputed.
Panchayat and it is under Panchayat and Rural Development Department.
We're just allowing the facts to be going through the facts.
Yes.
You were deputed initially to DRDA,
Yes.
which is some kind of a society under the
Yes.
PNRD.
May I put it this way?
Hmm.
I was sent on deputation to Panchayat and Rural Development Department,
And then
and
posted it
Panchayat and Rural Development Department sent me
to
to
DRDA. To
DRDA. They had a choice.
So essentially, your deputation has always been to PNRD.
My deputation was in the Panchayat and Rural Development Department. They were my master during the period of deputation. Of course, I held a lien in the post of the parent department.
Oh, correct. Yes.
That is it.
So my humble submission before your lordship is that, my lord, that as the prayer, my lord, is for date of the final absorption, my lord, is concerned, that is the 2016 only, my lord, 1/10/2016. And it's not a case, my lord, that petitioner has joined on deputation and automatically he has been absorbed permanently, my lord. This is not a case, my lord. In this case, my lord, his deputation was over, my lord. Thereafter, he approached the High Court.
What does the FR say about it? What are the provisions of FR, Mr. Tiwari?
I'm sorry, my lord. I'm not carrying anything. My lord, there is nothing to the contrary. This is the law, my lord, is if you are absorbed after coming on deputation, past services in the equivalent post will have to be counted.
That's correct.
That's the law evolved
What
service.
does the FR say about it?
My lord, I'm sorry, my lord, I don't have any copy and I have not again verified that, my lord, but to my understanding, there is nothing to the contrary. But if necessary, I'll look into that.
I think
Nothing
it's
can be
necessary to
done.
look into what the FR has to say.
My lord, very well.
Because
I'll look
it
into that.
has to have a relevance to
my lord. I'll look into that. If there is anything relevant to our case, my lord, I will certainly come back to my lord. I will look into that. In that case, my lord may post it to some other date.
And what do you say regarding the judgment he has relied upon?
Those cases, my lord, on deputation, my lord. Those cases law cited on deputation only, my lord, not on permanent absorption, my lord.
What are you saying?
Because these cases, my lord, he is not automatically absorbed permanently, my lord. That is why those cases may be, my lord, those persons, my lord, were automatically absorbed, and those joining date was counted from the beginning, my lord. But in this case, there is a gap, my lord.
There is a gap on the date of final absorption.
My lord.
But is there any dispute with the fact that he continued to work?
Initial, that person, that I have to also, my lord, confirm from the department whether he was officially continuing or not.
Your affidavit doesn't say anything to the contrary.
My lord, that is correct, my lord.
Why should we now
But the
look into
document
the
is,
facts which are not disputed?
document is there, my lord, because after the vacation of that order was there, my lord, that he was already revert back to his parent department, my lord.
Have you stated it in your affidavit? I don't find anything.
But as their pleaded case, my lord.
Hmm?
That his,
There was an interim order.
my lord.
As you say, the interim order was vacated, finally disposed of
Yes.
with a direction to file a
My lord.
representation.
This is admitted.
But during
admitted
the
position,
position, was he repatriated ever?
this is admitted position, my lord.
What is admitted?
My lord, it is admitted that after the judgment, my lord, where the interim order was vacated, he approached the authority, my lord, for final absorption.
No, that's all right.
That
But
is why
during the currency of till the time he was finally absorbed, was he repatriated back?
my lord, that person, that position, my lord, I shall apprise on the next day, my lord.
My instruction is, my lord, he continued officially. He was not repatriated, and finally he was absorbed.
In fact, your affidavit doesn't say anything about
It
it.
doesn't say that.
I'll ensure, my lord. And some earlier also, my lord, the candidates, those who are finally absorbed, and now their date of joining of final absorption, my lord, is the date of after the absorption date, my lord.
They did not have the opportunity of having legal
Right.
advice of Mr. Tiwari.
My lord.
So
Yes, my lord.
maybe, we don't know. So his only claim is that his services will have to be counted.
But apart from that, my lord, I'm asking myself, my lord, that the prayer, my lord, whether that can be allowed, my lord. The legal position is a different thing, my lord, whether what he is eligible for or not, my lord. But the
My
prayer,
lord may mold the relief.
But
I'm
the
not
prayer,
pressing
my
upon
lord.
those. My lord may
Prayer,
mold the relief. I'm not pressing
how
upon except.
can one claim that my final absorption date is the date of joining initial in the deputation stage, my lord? Because admittedly, after the final absorption order, he joined, my lord. The final absorption date, how can change, my lord? The benefits they can claim, my lord. It's a different issue, my lord. But they are asking for the changing of date of final absorption, my lord.
Can you take us to the paragraphs again, Mr. Tiwari?
Very well, my lord. I'll
The
look into the FR.
No,
I'll get back to my lord. I'll have the copy of the FR. I'll look into that. Because since I was familiar with this principle, my lord, I didn't look into the FR. I'll do that. It's my folly.
I'll also explore some if I can bring something, my lord, including judgment, my lord.
which is why we asked you whether the matter is ready for hearing. You agreed that yes, you're ready for hearing. Now, if you want to hunt for facts, you don't hunt for facts after the matter is ready
My
for
lord.
hearing.
That portion I was not thinking, my
My
lord.
lord, tomorrow I'll get back to my lord and with
Not
FR.
tomorrow.
At least one day. my
Third
lord.
learned counsels for the party,
Okay,
Mr. Tiwari,
okay.
senior counsel for the
FR is due.
petitioner, and Mr. Dotto. for the respondent, PNRD department. After hearing the matter for some length, Mr. Tiwari submits that the councils of the bar submit that matter be taken up on some other date, enabling them to refer to the fundamental rules and secondary rules of the state of Assam. Accordingly, matter stands deferred till give a date.
It could be tomorrow since my lord has already heard it.
It's not possible, my lord.
Tomorrow is not possible.
Or could it be Tuesday?
No, hearing that, man.
Another date, Tuesday, Thursday.
My lord, if it is Tuesday, my lord, the 12th,
Or 14th,
the 14th, 19th, there may be problem. 19th, there may be difficulty.
21. 21. Oh, 21.
This
I may
one's
have-
Wednesday.
21, no problem.
No,
14th,
19th is
14th,
Saturday.
14th of
You sort your dates out. We are
Semi-
fixing the matter, whatever date you want.
14th or 20th.
Yes, yes.
14th.
14th, I guess.
14th, all right.
14th.
September or yes. Oh, sorry.
We are in September.
Yes.
Oh, yes. All right. All right.
Right. I'll have it.
My lord, would it be parted or? Better, my lord, because my lord has heard it.
The issue is on a very short point.
Anyway, that's why we don't let it be parted or better.
We don't want to keep it part heard that way because you see part heard,
That's why, my lord, I want it tomorrow. Because FR, that's all, nothing else. But for
tomorrow,
FR.
had it been on Monday, Tuesday, it's a different issue, but
Then, my lord, next Tuesday itself, my lord. That's why Tuesday also I'm willing. I'll be here. Next week, Tuesday, because it's a short matter.
already here. We are having it on 14th.
That is September, my lord. So that's
We
why.
are already in September.
Oh, we are in September. I'm sorry. My lord, I'm going crazy.
The same calendar perhaps is applicable in Arunachal.
Thoroughly confused. Sorry.
Yes. So we'll have it on 14th.
Oh, very well, very.
All right.
Itu dah hari scroll for it. We'll call again. Huh? Yes, 23. What do you say?
We have filed our affidavit, Lordship. In that affidavit, we.
Let us call up the matter again. The counsel for the petition is not available. Yes. Maridu.
Proxy may take up WPC number 2677/2019.
Yes.
Proxy already heard the matter for some clarification. So Proxy may come to page 70.
70.
Yes, sir.
Yes.
Proxy close 2.
Hmm.
The scheme, the erstwhile scheme, which were operational on 18/7/2017 were as follows. 2.1 is for Jammu Kashmir, notification number 56, 57, and 01. Then 2.2 Himachal Pradesh, notification number 49/2003 and 50/2003. Then number 3, it is for Northeast, including notification 20/2007 direction. Now, let's say, come to close 4. Eligibility units. Eligible unit means a unit which was eligible before first day of July 2017 to avail benefit of ab initio exemption or exemption by way of refund from payment of central excise duty under notification, as the case may be, issued in this regard listed in para 2 above and was availing the said exemption immediately before 1/7/2017. The eligibility of units shall be on the basis of application filed for budgetary support under this scheme with reference to, now also important, A, the central excise registration number for the premises of eligible manufacturing unit and existed prior to migration to GST. Then clause B, the GST registration for the premises as a place of business where manufacturing activity under exemption notification 49 2003 dated 10/6/2003 and 50 of 2003 dated so and so were being carried out so and so. So there is no mention of notification number of 20 of 2007
So this is only for
for the
Himachal and Uttarakhand.
Himachal and Uttar Pradesh. Under the circumstances, the petitioners, they are not entitled to benefit under the scheme. Because it was omitted. There is no mention of early notification in the eligibility condition. Lordship further, the circular dated 10 January 2019 is the clarificatory circular laws. It is not changing any basic condition of the notification. It cannot be termed that by notification, the department wants to change the basic scheme law.
What was the provision under this scheme?
Lordship,
Under this scheme,
Lordship,
original industrial policy.
yes, Lord. It is annex here report.
Page number.
And Lordship 20 is not annexed here too. So I have a copy of the 2007 scheme law.
Must be there somewhere, I think.
And admittedly, Lordship, these industries were not either not registered or they were below the threshold limit. In our affidavit, Lordship, we have stated in paragraph 6 of our affidavit, Lordship,
So let us see the notification 20.
Lordship, that I've given to you.
Yes.
Video. Lordship, 4.C.
Yes, 4.C.
A manufacturer who intends to avail the option under clause A shall exercise his option in writing for availing such option before effecting the first reliance in any financial year. Then such option shall be effective from the date of exercise of option and shall not be withdrawn during the remaining part of the financial year.
Where is that policy?
That's it.
Where is the industrial policy?
So industrial policy.
Please come to clause number 5,
Clause number 5 of
this
2000.
notification. I think this is the criteria for exemption under the industrial policy.
The exemption contained in this notification shall apply only to following kinds of units, namely the new industrial units which commences commercial production on or after first day of April 2007, but later than 31st day of March 2017. Industrial units exist before the first day of April, but which have undertaken substantial expansion by work increase not less than 25% of the capital investment in the plan was made.
I think industrial policy is there in,
Yes, object for
Somewhere in the pleadings.
in this writ petition. Yes, page 52. Clause 5, excise duty exemption.
yes,
So it is a admitted fact that the petitioners either they were not required to register under earlier scheme, or they were found to be falls under the let's say that monetary scheme that monetary. That's why they were not. But under the present scheme, the budgetary support also. They were not fall under the eligibility definition of eligibility limit. So the benefit was not extended to them. And in subsequent circulars, it is clarified. Then they were not that they are not entitled to benefit under the present scheme.
will they not covered be by the clause 5 of the notification 2007?
Up to 2020,
2020 notification.
not see what happened, they were not required to be registered under this scheme. And also in paragraph 6 of our affidavit filed by the department, we have clearly stated the petitioner preferred to avail notification number 8 of 2003 as it was more beneficial to them, since not a single paisa of central excise duty was required to be paid, as their turnover was under threshold limit. Had the petitioner availed the benefit under notification 20 of 2007, they would have got refund of duty to the extent of value addition as prescribed in the said notification, not the full amount of duty paid to PL. And after rolling of the GST lordship, this phrase, all the earlier schemes were rescinded, and the fresh scheme was floated.
Now, what happens to units who now come into the threshold limit after 2017?
So they were excluded by this budgetary scheme.
Yes.
Lordship, this scheme was put under challenge. And the Honorable Chief Court in the Hero Motor case, although these points were not raised, but scheme as a whole was upheld by the Honorable Supreme Court. In Malhamal submission, Lordship, at this stage, after Supreme Court passed the order holding the scheme, cannot be interpreted in other way. And is as many as in 4 judgment, Honorable Supreme Court has said that the exemption notification should be.
They are not challenging the values of the scheme.
Yes,
They are
Lordship, that is correct.
they want to be covered by the scheme.
Yes, Lordship. But when because they were excluded by this this budgetary scheme.
No, this is in context to your submission that Supreme Court having upheld.
Yes, Lord.
It is not subject to challenge again. What I understand is there is no challenge to this scheme as
No, they are
such.
not challenging. This is also not my submission. My submission
They
is that
want the benefit of that scheme, which
Yes,
have been
Lordship.
given to other industries.
because they were excluded, so they are not entitled to benefit under the scheme. And this scheme was examined by the Honorable Supreme Court. Although the point raised by the petitioner were not were not placed before the Honorable Supreme Court. Even then, Lordship, any clause of the exemption notification, because it's a benefitary notification, Lordship. So it should be interpreted strictly, Lord. It is Lordship, one of the correct that other industry were given benefit, excluding these units, Lordship. But there must be an hard burning on the part of the petitioner also. When the scheme reward them from taking benefit on the scheme. Honorable Supreme Court in as many as 4 cases held that the scheme should be interpreted strictly as per its interpretation.
Yes.
Lordship, one case that is 2018 9 SCC page 1. Commissioner of Custom versus Dilip Kumar and Company.
Yes. Yes.
In paragraph 66.
Strict interpretation.
Yes, sir.
So far as exemptions.
Yes, sir. Exemption notification should be interpreted strictly. The burden of proving applicability would be on the CC to show that this case comes within the parameters of the exemption clause or exemption notification. In another case, Lordship 2022 6 SCC page 459. Paragraph 14, 15, 16, 26, and 27.
Yes.
2022 6 SCC page 459. State of Gujarat versus Aerosol Mittal Nippon Steel India. Here, same principle has been dictated paragraph 14, 15, 16, and 26 and 27.
Which judgment?
Proceed 2022-6, SCC page 459.
2022 6 SCC.
Yes, okay, page 459.
This is
State of Gujarat versus Arcelor Mittal Nippon Steel India.
okay. Then
Paragraph 14, 15, 16,
Hmm.
26 and 27.
this is for what proposition?
Same lordship regarding mistake interpretation of exemption notification.
Yes.
Then again, lordship, same principle was reiterated in 2022 5 SCC page 62. कृषि उपज मंडी समिति न्यू मंडी यार्ड अलवर versus Commissioner of Central Excise.
Okay.
Lordship, same principle was again reiterated in 2022 2 SCC page 725.
State of Maharashtra.
State of Maharashtra versus Vile Parle.
Yes.
So these are the four judgments. Lordship, on Article 14, I want to rely on 1999 3 SCC page 422.
99.3.
1999 volume 3 SCC page 422.
Name of the parties?
Babu Varghese and other versus Bar Council of Kerala. Proceed paragraph 31.
31.
Okay.
Yes.
I'm sorry, Lordship, this is regarding, it is the basic principle of law, long settled, that if a manner of doing a particular act is prescribed under the statute, the act must be done in that manner, not at all. The origin of this rule is traceable to the decision in Taylor versus Taylor, which was followed by Lord Rochi in Nazir Ahmed versus King, where a power is given to do a certain thing in certain way. The thing must be done in that way or not at all.
Yes.
Under the second lordship, since they were derived from benefit under present scheme, since they were not eligible also under the scheme, so lordship, they are not entitled to any relief under that.
Yes.
My lordship, kindly on the last occasion, lordship is asking a question about the interpretation of one of the clause, which my learned friend also pointed out. Lordship, can you see? It's in 1 minute. Number 5. Item number 5 minute.
You're taking up 2664 or
My lord, 2664,
2664?
page 71.
Yes.
at the bottom. B, Miller.
Yes.
GST registration for the premises as a place of business where the manufacturing activity under exemption notification number so and so, dated so and so, were being carried out prior to 1/7/2017, and the unit was not registered under the central excise. Now, these notifications there were two types of notification below. One was a notification whereby a person has to pay the tax and thereby get a refund, which was that northeastern region. And 4950, the unit was not liable to pay tax at all.
Yes.
Since he was not liable to pay the excise duty at all, the question of registration was not there. They were totally exempted.
Can you take us through these notifications? Let's go through the notification, 4950.
49 Your Worship.
Yeah.
In exercise of the powers so and so. What is it? 49. I've given it. Why you have not given at that time? When you were arguing
Yes.
section 3 of so and so, and the central government being satisfied that it is necessary in public interest so to do, hereby exempts the goods specified in the schedule appended thereto, other than the goods specified in action appended thereto, and cleared from a unit located in the state of Uttarakhand or state of Madhya Pradesh from the whole of the duty of excise or additional duty of excise, as the case may be, leviable thereon under the any of the aforesaid acts. Now, the exemption shall be applicable to this notification, and this should be applicable for a period of not exceeding 10 years.
Yes.
So, my lord, under these two notifications, the goods cleared from a unit located in the which was eligible was totally exempted. And since it was totally exempted, they were aware while framing the scheme that, you also may see kindly, GST registration, it has to be there after 2017, dated so and so, we are being carried out prior to 1/7/2017, and the unit was not registered under the central excise.
Because they were already exempted.
They are already exempted. Now, the condition of registration can only be there when they are liable to pay the duty.
Yes.
Since these units in Uttarakhand and Uttaranchal and other places were not liable to pay the excise duty at all, and thereby in the scheme it is specifically mentioned that after the GST they must be registered and manufacturing activity must be carried on prior to 1/7/2017, and the unit was not registered under the central excise.
So what your submission is that, but these notifications are applicable in state of Uttaranchal and Himachal. Not
I'm
for,
putting the case in this case and my case.
so is it your submission or is it that what you're trying to submit, that they were all along aware of the fact that there were certain industries which did not fall into the threshold limit or
No, they were not liable for registration.
exactly for whatever.
So the
Reasons.
Uttarakhand and these notifications, they were aware
Hmm.
that since they are totally exempted from the payment levy of duty at all or excise duty, and thereby they will not be registered. And
Yes.
thereby they put the condition that they must be registered under GST after 1/7/2017. They must be carrying out the manufacturing activity prior to 1/7/2017, and they were not registered under central excise.
Yes.
Now I am putting my case, comparing my case with the case of this exemption in respect of the other two states.
Mm.
I am registered under GST. I was manufacturing up prior to 1/7/2017. And because there was no levy, I was not registered under the central excise.
Yes.
Now, can it be said? The lordship has to see the intention. Whether you can make a condition that there must be central excise registration when it is very much, they are very much aware that central registration will not be there.
Yes.
Having fully aware that in respect of the two states, the central registration, excise registration cannot be there. They have specifically made a provision that those units not having the central excise registration
Yes.
and industry which was exempted by notification and an industry which was eligible but was exempted by way of the statutory provision cannot be treated in a different manner.
Yes.
Now you'll also have seen the condition 4.1 million.
Yes.
Eligible unit means a unit which was eligible before 1/7/2017 to avail the benefits of ab initio exemption or exemption by way of refund from payment of central excise duty under notification, as the case may be, issued in this regard, listed in para 2 above, and was availing the said exemption immediately before 1/7/2017. Now, an industry which was established in the year 2014, assuming for the argument's sake, was availing the exemption up to 2016.
Yes.
For some reason or other, from 16 to 1/7/2017,
the industrial unit was closed. The industrial unit started production again from August 2017. Will it mean, Millard, that that industrial unit will not be entitled to, because it says and was availing the exemption immediately before 1/7/2017, meaning thereby just immediately before 1/7/2017, the industrial unit must be availing the exemption. Neither the industrial policy nor the notification number 20 of 2007 anywhere stipulates that an eligible industrial unit must avail or claim benefits for the entire period of 10 years. I am entitled for the benefit of 10 years from the date of commercial production. If somebody has not claimed the exemption, assuming Millard, he was entitled for the refund, he was entitled for the exemption, he has not claimed the benefit for 3 years. Whether that industrial unit will be disentitled to claim the benefit for the remaining 7 years, because the exemption is for 10 years. Notification and the industrial policy nowhere says that for 10 years you must claim the benefits, otherwise you will not be entitled to. It nowhere says.
Yes.
That's why in the notification you'll also find the refund is in respect of the amount paid through account PLA. So in respect of the industrial units who have got sufficient Senvet credit, and after utilization of the Senvet credit, there is no amount payable through account PLA, no refund will be granted, because he has not paid any amount in cash. Whether it will mean that those industrial units were not availing the benefits, because as per the notification, the exemption is only in respect of the amount paid through account PLA. If something has not been paid through account PLA, refund is not granted. He is not entitled for any refund. If the interpretation which has been put forward before Lordship is accepted, then if an industry immediately before 1/7/2017 has not claimed a refund, 20 of 2007 will not come into operation at all. But in respect of those industries who were not paying, who had not paid a single PI before 1/7/2017 to account PLA, entire amount was paid through adjustment of the senior credit, were also denied the benefit on the ground that they were not availing the benefits prior to 1/7/2017. When the writ petitions were filed, subsequently a clarification came that no, they will be entitled to.
Where is that clarification?
You also see the second paragraph. The documents specified in para 6, 5.7 of the notification are able to establish that these units were availing the area-based exemption prior to 1/7/2017, may are not paying duty from as cash as per the restriction placed in the scheme itself, cannot be detrimental to the status of availing the notification, and these units should be considered as eligible for the benefit under the budgetary support scheme.
This has come recently.
Well, yes, sir.
This clarification has come recently.
Recently, like in 2023 only, February 2023.
This is in respect of
Well, those industrial units,
Uttarakhand and no.
no, this is with respect to all industries. Bro. There were a number of writ petitions were filed before this honorable court. The cases were heard at length.
So what remains now?
Well, I'm saying that when this notification says that if after utilization of the senior credit also, if no amount is payable, then also those units will be
Eligible.
held to be availing the benefits. Though no refund was granted. Now, in my case,
You are not registered.
not registration because the
Not
liability is
required.
not there. Like
Not
Uttarakhand,
required to pay. Not required to pay central excise.
central excise. If the central excise has not been paid, then this notification or clarification that availing the benefits will mean only the cash payment, because 20 of 2017 says that the exemption will be only the respect of the payment made through account PLA. Now, how you can put a condition of central excise registration when the said registration requirement is impractical, and you yourself are very much aware that in certain cases the registration will not be possible, and thereby put such condition in the criteria itself in respect of the two states.
Yes.
Meaning thereby, my lord, the central excise registration prior to 1/7/2017 cannot be a condition in respect of the eligible industrial units who were not required to be registered under the Central Excise Act. one cannot say that in respect of two states, the registration requirement is not there. But in respect of the northeastern region, the requirement of registration will be there, but irrespective of the fact that such registration cannot be procured.
Yes.
If my learned friend can say that prior to 1/7/2017, in spite of the fact my threshold limit was below the turnover was below the threshold limit, or goods were specifically exempted, the registration would have been granted by the department, and I have not taken it.
Yes.
My learned friend was again reading from the affidavit of the notification number 3 of 2003.
Yes.
I don't know where from these statements are coming that they were availing the benefits under the 2003 notification when it was not applicable at all. In 2007 notifications were after the notifications were issued as per the industrial policy of 2007. Now, when 2007 industrial policy, the industries were established, how those industries were availing the benefits under the 2003 notification? One cannot think of that a notification issued prior to the announcement of the industrial policy, and 20 of 2007 was issued to give effect to the industrial policy resolution of 2007. There is no question of basis of saying that they were availing the benefit under the 2003 notification. What benefit I will availing when the industry was not there? But to the effect, a similar situation arose before the Tripura High Court.
Before?
Tripura High Court, in respect of the transport subsidy, where an industrial unit, after being established, continued only for 3 years
Yes.
and was closed down. Though they were entitled for 10 years.
Yes.
And the argument was that the industry is not in operation. Only for 3 years it was there, and thereby they are not entitled to. 2021 SCC online, Tripura 273. Lossy Mekalisi, paragraph 15.
Yes.
Paragraph 15, I believe, no? We do not find the objection as raised by the respondents to oppose the petitioner's claim on transport subsidy are valid. To begin with, the objection that the petitioner's activity did not amount to manufacturing activity has been raised by the respondents in the official correspondence. In any case, it does not require much effort to turn down such an objection. The admitted fact is that the petitioner is engaged in the crushing of the boulders into stall ships, stalls used for construction activities. Thus, an entirely new article, though through the manufacturing process, which the petitioner subjects the raw materials to come into existence. Further, the objection that having started as a manufacturing unit, the petitioner later on was engaged in the activity of a job worker and would not make the petitioner ineligible for the transport subsidy. It is the principal agency for which the petitioner may be carrying out the job work to bear the cost of transportation, and when such an entity claims the transport subsidy, the question of eligibility may be examined. However, the petitioner has claimed the transport subsidy during the period it has undertaken the transportation of raw materials for the manufacturing activity. The eligibility period for claiming subsidy may be 5 years. The scheme nowhere provides that only if a new industrial unit continues such manufacturing activity for a period of 5 years, that it can claim the transport subsidy. Therefore, even if it is pointed out, respondent, the petitioner at some later point of time, after commencing the production, not engaged into the same activity as a job worker, this would not amount to breach of any of the eligibility conditions of the scheme.
Yes.
So to say that a person must be availing the benefit just immediately before 1/7/2017 to be entitled to the benefit, though the industry is eligible for the claiming benefit for 10 years and the residual period is there. In my humble submission, this is absolutely contrary to the industrial policy as well as the notification. My learned friend also argued about the Hero Honda.
About?
As you lost it ever,
About
in Hero Honda case of Supreme Court.
Hero Motorcorp.
Hero Motors. Now, in that case, the argument which was being advanced were not at all considered, they were not in challenge at all. Now, if, as you also know, that the judgment is that at what it decides.
No, in the first place, you are not questioning the budget, you are not challenging it.
I am challenging only on Article 14.
You are challenging the non-inclusion.
I am challenging that the exclusion which was there, that should be struck down.
Uh,
If I challenge the scheme, it's that scheme.
You're not
is-
challenging the scheme.
Then
Therefore-
what will be available with me? Then nothing is will be available. So that argument in my humble submission, a scheme may be there, one person challenging the scheme. The Supreme Court cannot say that the irrespective of the whatever clauses may be there, the entire scheme is approved. But the Supreme Court is the approving authority. Supreme Court decides the dispute which is brought before the
Mr.
court.
KL wants to put the proposition that once the scheme has been examined in its whatever, in its form, it is held to be
My
approved.
lord, a scheme is examined on the basis of the controversy which is brought before the court.
Correct.
A particular controversy is brought before the court. It cannot be said that the entire things, whatever a scheme is there, then it will be very easier for the department. Put a dummy person as a petitioner, challenge something nonsense, put before the court, get it upheld, and close the doors for all the times to come. It will be very easy to close the doors for all.
Not only for the department, for us also.
Well, can it be such a proposition be advanced?
Yes.
My learned friend was again and again placing the judgments before Lordship of the strict interpretation. Those judgments will be applicable when something interpretation of the clause is there. We are not on the ground that this interpretation, that interpretation. We are saying that exclusion is hit by Article 14 of the Constitution of India. Where is the question of strict interpretation? Whether one can say that Article 14 will not come into operation at all and strict interpretation should be there. Whatever you lay down, that should be treated as a Bible. Nothing can be, whatever you may do, when it is interpreted in a normal way, strict interpretation should be given. There is no doubt about it. For that, the judgments are not needed. It is from the very beginning, the judgments are there. My learned friend was placing the judgment of Supreme Court from Taylor, Najir Ahmed, all throughout, judgments are there. Then when the things is to be done in a particular manner, that should be done in a particular manner only. That applies to them. that when a particular thing is to be done in a particular manner, that should be done in a particular manner only. You are not doing it,
or not at all.
not at all. If you do it, then give it to all who are eligible. Or don't give. In fact, his judgments, according to me, will apply should be in my submission. That if you give the benefit to eligible units, then give to all. You cannot say that I do it, but I will do in this manner. You can't do it. There is a Tripura High Court, another judgment also, but I don't want to multiply in the same score. So my submission for lordship is there, that my lord, the question which is to be seen is whether the industries were eligible or not, whether the industries were manufacturing activity or not, whether the residual period has remained or not, whether they are registered as the GST or not. One cannot put a condition which is impractical of compliance and knowing very well that there may such a condition will also be there which is impractical of compliance. In one clause you have said central excise registration, in another clause you have said not registered. Because you know that certain cases may be there where the central excise registration condition cannot be fulfilled. Knowing fully well, you cannot say that no, so far Uttarakhand, Himachal, all these things is all right. For northeastern region, my learned friend was saying herd burning. What herd burning? There is no herd burning. This is a matter of right. Herd burning when you are giving something, begging somebody, so you are giving to somebody, and I say that my herd burning. I am not herd. There is no question of herd burning. We are here not begging anything from the central government. We are here claiming by way of right, legal right of ours to be entitled to the benefits. The central government cannot give a step-motherly treatment to one eligible industry unit by giving the benefits and denying the benefit to another eligible industry units which stands on the equal footing.
Yes.
In my humble submission, my lord, the petitioners before your lordship are entitled for the benefit under the subsidy budgetary support scheme, and denial of the said benefit to the petitioners is hit by Article 14 of the Constitution of India, as well as the same goes against the spirit of the industrial policy, the excise notification, and the purpose and object and the spirit behind formulation of the budgetary support. That is my heart. I seek liberty of lordship to submit a written submission
Yes. Both parties.
No.
You can do
within
it.
4 or 5 days.
May I write down one citation or if I forgot to,
Hmm? Hmm?
on Article 14.
Sorry?
On Article 14, 2012, 1 SCC, page 226.
You've given it here.
It is there, Lord.
Knit dip textile.
Yes, Lord.
See,
Okay.
I'm highly obliged.
thank you, both the councils, for extensive argument in the.
Comparisons and my lord, he will check up only the comparisons of judgment.
Yes, yes, yes.
So that which are not there, we can.
Heard reserved.
May I please allow? For item number 18, we may also allow to file our written submission. Oblige.
Yes.
Lordship, all these three are promotional matters, Lordship.
Hmm.
Petitioners who were initially appointed as junior engineer, Lordship, on being acquiring the higher qualification, they were promoted to the post of assistant engineer, Lordship. But the rule says, Lordship, if on acquiring the higher qualification, a person is promoted to the next higher career, Lordship, it will be considered as direct recruitment.
Hmm.
So he was initially a diploma holder. He became a degree holder.
Then promoted.
He was promoted without waiting for his turn to come, Lord. So other junior engineers will get the promotion to the assistant engineer
By virtue of service,
service.
length of
I mean,
service.
length of service, seniority only after
And he
coming
gets it
within
on basis of
his qualification.
higher qualification.
Yes. So that was his, accordingly, he was promoted in the year 2003 Lordship.
Hmm.
And his name was, their names were placed in the seniority list.
Hmm.
And that is where their grievances were there, Lordship.
Hmm.
They were placed under the directly recruited assistant engineers. Now, Lordship, in this case, Lordship, petitioner is not appearing since last 2-3 days, Lordship. And on being asked, Lordship, department sent me one letter written by the petitioner at serial number 19, Lordship.
Hmm.
Now, he is saying that, Lordship, he is not having any more grievance, Lordship, as he has already got the promotion, and now with the seniority list, he has no grievance, Lordship.
You're referring to this Nirmal Kaur.
Nirmal Kaur, Lordship.
He has written some letter.
He has given a letter to the Deputy Secretary to the Government of Assam, Lordship, PWD Roads Department, and where he states, Lordship, with due respect, I have the honor to inform you that
You give us a copy to the
Lots of
court master. Take a
Lordship,
copy.
this matter may be closed, I think, on
Then the other matters,
same issue, Lord. Same issue. But other matters, Lordship, we have not received any such letter, Lord. In one case only. But these matters may be, I think, close on this one.
same council appears. Party matter. Same council. नाम तो लगाई दो. नाम तो लगाई दो.
Cause this concern, you know.
You put the name of Endeka.
And এখন মেইলত গৈছে দেই আপোনাৰ লেটাৰ
All right, we'll call it up again at 2 o'clock. Meanwhile, if you can hand over a copy
Lordship, I have given already.
given, we'll call it up at 2 again. Let us see
Lordship.
someone appears.
Passing on it. Give me a second.
Yes.
Right, Your Lordship. In this these two matters, Lordship, earlier Mr. H. Gupta was appearing like this. Now, since he has been empaneled as central government counsel, Lordship, so the respondent, one of the respondent is a central government, so he can't appear, Lordship. So I'll appear in that case, Lordship. So in that case, Lordship, matter may be taken up on Tuesday. And my Lordship, on my submission is also there. And the second case, Lordship, that is the permission, item number 24. Lordship, here the petitioner has been granted pension, Lordship, as per my information, Lordship. So, Lordship, the government may, Lordship, they bring the instruction on the next day whether the date, whether the gap, which was lordship, initially he was lordship, his appointment was lordship initially, he was not renewed lordship, and that gap, whether that gap has been counted for pension or not.
You're referring to WPC 1135.
No.
He's making submission in two cases, 22 and 24, at the same
20 and
time. also.
24, Lord.
But both are different facts.
Both are same, similar.
It took Anganwadi 22 too.
22.
23 and 24.
Yeah, 22 was called for. Baba, tumi aloma agota ahi gula.
Item 22.
Not, sorry, Lord.
Who is there in item 22?
There was a complaint in respect of the deponent lordship here, but it was being withdrawn. So in our affidavit lordship, we have mentioned. At para number 5.
Mr. Mahmood appears.
The name is M.E. Mahmood lordship.
Reflect for it with notice. Yes, madam, you are appearing.
Yes, my lord, Passover matter for Ezron, file is not asked.
Huh?
Passover matter for Ezron, my senior election code number 17.
Call him at 2 o'clock. At 2.
Lordship, 2 o'clock, fixed code number 3.
Day after tomorrow.
Lordship, 1 week.
Let it come.
Monday. Lordship.
Huh? This is 2012 matter, so we want to find out whether anything survives. You ask him, or if there is nothing, we are closing the matter.
Lordship, 1 week.
What 1 week? 1 week for what? Nothing remains here. We'll take it up on 12th. 12th.
Okay, Lord.
The request of MS so-and-so matter stand adjourned to 12th. '23, '24, you want it on
Tuesday, lordship.
Tuesday.
In the meantime, lordship, government may be directed to lordship in the instruction regarding item number 24. Because in 24, the petitioner has been receiving pension, lordship.
All right, '23, '24 at the request of Mr.
Yeah.
Govindar
Lordship.
stands adjourned to 12. Mr. C. K. Sarma appears for respondent number for the state respondent. You get your instructions and see.
2 weeks. Lordship.
2 weeks.
That one of Kamrup lordship, one week lordship.
Huh?
Otherwise, everything is in service lordship.
No.
So medical fitness.
Can you get it by 14th?
That is only 1 week lordship. Exactly 1 week.
All right, 19th.
Yes, 19 you can give it a try.
19th.
19
It will be on 19th. Yes, 19th.
19. Obliged, lordship.
Yes.
May it please the lordship. The lordship, item 25, item 27, 28, 29 and 30, your lordship, are filed by Mr. M.K. Chaudhary, your lordship. Item number 26 is filed by my senior Mr. Jay Baldwin. The matter here, your lordship, pertains to the inter se seniority of forest rangers, your lordship, in the forest department.
Hmm.
Item number 30, your lordship, is the latest matter, your lordship, which takes care of all the facts, your lordship. So if your lordship please take up item number 30, WPC 1148 of 2021.
Hmm.
In fact, before your lordship,
No, for my learned friends, my lord, traverses in deeply, my lord. Lordship will kindly peruse the earlier, last order, my lord. Some time was given to us to finalize these rules, my lord. So I further pray for some more time. My lord. Rules are will be sent to APC for vetting very soon and will be placed with the cabinet. Item 26 of December.
No idea, no idea. 26th of November.
Time list. 26
Sabotage.
No, 26 to last week.
What is the status of the rules?
My lord, they are under preparation and very soon they will be sent to APSC for vetting. After that, they will be placed before the cabinet.
So
Your lordship, subject to your lordship's in the matter. The rules, your lordship, will have no bearing on the matter. The issue here, your lordship, that has been raised by the petitioners is that the private respondents were not selected by the APSC. The issue is completely different. And if your lordship sees the initial appointment orders, the rules have been in the pipeline for the past 35 years. Which is a fact, your lordship. It's an admitted fact. The rules are in the process of being finalized for the past 35 years. The only reasons the rules cannot be finalized is because rules cannot validate an outsider being given an outsider entering the service. So the issue here, your lordship, is completely independent of
this will
whether
require some hearing.
it will require an extensive hearing, your lordship. My learned senior is also not present today.
Mr. Kane Chaudhary appears for the
Yes.
private respondents.
So your lordship will kindly fix a date for urgent disposal of the matter, your lordship. This has nothing
Matter
to.
is listed today and
Yes,
you are
it-
asking another date for an urgent disposal.
Point is
I'm willing to argue the matter, your lordship, but my learned senior is not
only
there.
one point is there, my lord. The fixation of the seniority.
That is
Yes.
the point.
Only that point, my lord.
Yes,
Hmm.
which has no relevance with the service rules.
Service rule, my lord, APSC has given our category, my lord,
You
serial number.
just, when you want,
The
you
records
can,
speak for themselves. I'll leave it to your lordship to fix a date, your lordship. I'll leave it to your lordship.
no, fixing a date, the matter is already fixed today.
Yes,
So we can begin the hearing if you
we
want.
can begin the hearing, your lordship.
Yes.
If the parties are ready, we can start
Yes, my
hearing.
lord. Otherwise, we are ready, my lord.
My lord, let the learned seniors appear and contend their cases, my lord. I am not in a
The
position.
seniors are not available.
Six, my lord.
Perhaps Mr. Kane Chaudhary with his assistance will be required by this court, my lord. In his
Yes,
absence, my lord. you go ahead.
last week of September. No, it's last week of September.
Any Tuesday, Thursday, my lord, lordship's convenience, my lord, so that it can be disposed of, my lord.
How many councils are there?
There are two sets of councils. I'm being led by Mr. M.K. Chaudhary, your lordship, and my learned senior friend for item number 26. So there are
And
two
the
sets.
pleadings are complete for all.
The pleadings are all
They have
complete.
not filed their affidavit.
For the past 10 years, that is not in dispute. The records will speak for themselves. My learned seniors matter is a very recent matter. If your lordship sees item number 25, it's a 2013 matter.
Why is it pending?
It has been pending
2013.
because
One on the other pretext, they take time, my lord, filing affidavit or preparing draft service rule, these things.
My lord will detect his matter then.
Huh?
My lord will detect his matter. We'll see.
Yes.
We'll file affidavit in his matter.
What, which matter?
item number 26.
Let him see. My lords, this will require some extensive hearing, and I also has to appraise this court as to the exact status of the what is happening to the rules. I'm not disputing anybody's claim. Let the rules be very clear. Neither we are declining anybody's
Your
promotion.
rules are
neither resisting.
pending.
My lords,
Your rules are pending
My
and
lords.
rules will not see the light of the day in next 2 weeks or 3 weeks.
exactly, my lord. That
Then-
was the point I would try to make at the first time, my lord.
Then
So my lord will kindly
in
have.
the
after
absence of the
some time.
rules, how are you governing the service conditions?
There are some other old rules, an old set of rules, and it is. My lord will
There is
see
no
there's a-
bar,
my
there
lord
is no
s-
bar for the draft
my lord-
service rules to be put into
No, my
place.
lord, kindly see that letter on basis of which this it matters fixed so belatedly. That letter is self-explanatory, my lord. That is a part of record.
In fact,
As a
Mr.
13-6 letter, my lord.
Lordship will permit me to make a small submission. In 1989, there was an order of appointment which states that pending finalization of draft service rules. It's been 35 years since the lordship. In fact,
H1.
so irrespective of that, your lordship can hear the matter.
I
Service
can
rules-
hear it today. We'll
The
fix it
service
up at
rules-
2 if you are agree.
I can start your lordship for next week then, but
Perhaps, my lord, it'll remain half-baked because Mr. Chaudhary has to also listen to his submissions and also revert back.
Last week of September, Your Lordship, of final disposal.
Date are ready. 26th,
26.
I'm grateful.
submitted by Mr. N. Decca Learned Council. That petitioners have verbally informed him that they are no longer interested in pursuing the matters any further as their grievances have been resolved.
Lordship may not record it because one has been promoted, one has retired.
All of them had got prompted. Lots of only issue was there.
All right, they are not interested in pursuing the matter. Mr. P. Nayak, learned counsel for the respondent, also places on record a copy of the letter written to the Deputy Secretary, Government of Assam PWD Roads Department by the petitioner in WPC 532 of 2012, stating that he wants to withdraw the case and have no grievances against the department. In that view of the matter, the petition stands closed. The interim orders, if any, are vacated. Disposed.
Item number 37 of daily proceedings. Specifically, agenda matter for today.
No, Mr. Counsel, this mentioning hour is over at 10:30. You wait for your turn. Yes. Yes, any information?
Yes, madam. As per my information, madam, the respondent number 5, he joined APDCL on 5/3/2019 and he resigned on 6/2/2021. And that subsequently, the respondent number 6, 7, 8, they are already promoted to the next higher cadre, next higher post. And in subsequent, there was a process initiated by the APGCL in 2020 for the recruitment of 2 assistant accounts officer that has been appointed. Total cadre strength as on today is 20 and man in position is 10. 10 vacancies are now available. Lordship.
So
Whether the petitioner who responded to an advertisement of 2018 can be considered to the vacancies which arose subsequently, that Lordship ultimately has to be decided.
No, this is in the phase.
Lordship.
You will have to identify the person who was last appointed.
Lordship.
You give us the name, we
That-
treat them as party.
That post, the person who has resigned, that is not filled up. And
No. In
Yes,
the
the general
list of
staff-
10 persons or 20 persons who were appointed,
Lordship.
there must be select list. That
Yes,
select list will have the
This-
names of the persons who are required to be were appointed.
Malad.
So the person who was appointed at last, the last number,
Lordship.
Is 24.
in the event
Hmm.
the petitioner's case is allowed,
Lordship.
that person's may have to be, appointment may have to be interfered with.
Lordship.
So he becomes a necessary party.
Lordship.
Unless you say that there are posts vacant, if the petitioner can be appointed, assuming his petition is allowed, he can be appointed, then his service benefits will accrue from the date when the other persons were appointed. Then we don't need to implead anybody.
But page 23, NHF 5 is the order, appointment order, by which nine persons were appointed.
So where is this Mr. Tinku Das?
Yes, Malad. Page 24. Under
Page 24
petition,
last.
Malad.
You have not arrayed him as party.
Initially, I not, Malad, by the Malad, high application, Malad. I am praying for the lordship, Malad, for arraying him as a party.
Yes, who is appearing for the person? So we are not concerned with the other person. We are concerned with only one post. So
Party number 8.
we'll implead number 8 as the respondent.
Right.
Heard learned counsels for the parties. This IA. This IA has been filed for impleadment of the opposite parties as respondents in WPC 7448. Stop. The writ petition was filed by the petitioner putting to challenge the selection and subsequent appointment made to the, what are the posts? What post?
Assistant account officer.
Assistant account officers, accounts officer under the in the APGCL.
Yes.
Generation, it is in generation.
Generation. 3-4, response number 3-4.
APGCL, namely respondents number 3 and 4. Stop. The claim of the petitioner is that in respect of certain questions, although claim of the petitioner is that during the selection process, he was not awarded marks in respect of question ID numbers 10343, 10345, 10337, and 10338. Although, according to the petitioner, the answer key was correct. Stop. It is the case of the petitioner that in the event the appropriate marks are allotted to the petitioner in respect of these question IDs, question ID numbers, Kumar. He would score higher marks and he would have been included in the select list. Stop. The said grievance of the petitioner has not been acted upon by the by the respondent department by referring the matters to the experts, subject experts, if required, to verify whether the answers given by the petitioner in respect of the questions referred above are correct or incorrect. Stop. It is the submission of the petitioner that in the event his writ petition is allowed, then the person who was appointed, the person was appointed through the selection process and who was at the bottom of the select list may have to be his or her appointment may have to be interfered with, and accordingly this I has been filed. Stop. Para. It is submitted by Mr. D. Nath, learned counsel appearing for the APGCL, that the opposite party number 5, Sri Rajdeep Bora, had since demitted his office.
He resigned on 6/2/2021.
As he resigned on 6/2/2021. Stop. This vacancy, along with other vacancies, were subsequently advertised and
No, that was not advertised.
Not advertised.
That was not advertised. Subsequently to advertise, those to fill up. As on today, position is not.
that post is vacant.
Yes.
That post is vacant.
It is submitted that the post which was held by Rajdeep Bora has not yet been filled up by any recruitment process. Stop. That apart, it is submitted that the cadre strength of the assistant accounts officer is 20. What is the cadre strength?
Sanction is 20. Sanction post is 20.
Cadre strength of sanction post is 20.
Lordship.
And as on date, men in position are 10.
10.
Stop.
Because these all the respondents, they have been promoted to the next cadre.
The opposite
They are
parties,
also not
number
in the cadre.
6, 7, and 8 have in the meantime
Lordship.
been promoted to the higher post of,
Lordship.
to the next higher post. So, there are Mr. RB. Kohai. Learned counsel appearing for respondents number 5, 6, and 7. 5, 6, 7, and 8 submits.
Not on behalf of 5, my lord, on behalf of 6 and 8.
6, 7, 8 has objected to the prayers made for implement as party respondents by filing. You filed some objection.
I had filed it today morning. Not
Then why did you not bring it? Why did you not take permission to bring it? Submits that he has filed an objection opposing the prayer for implement.
my lord.
Having heard
Respondent number 1 and 2, my lord.
Mr. S.P. Sharma appears for respondents 1 and 2,
APDCL, my
APDCL.
DCL.
Why are you required as a respondent?
My lord, we were the one who had set the question paper.
It is submitted by Mr. Sharma that respondents 1 and 2 were the authorities who had conducted the selection process and set the question papers. Stop. Where having heard learned counsels for the parties, considering the fact that the cadre strength of assistant accountants, assistant accounts officer, sanctioned cadre strength of assistant account officer is 20, and as on date, men in position are 10. It will meet the ends of justice if a direction is passed to the respondent authorities, more particularly respondents 3 and 4, to keep one post of assistant account officer vacant till disposal of WPC number 7448 of 2019. Stop. The said post shall not be filled up without further leave of the court. Stop. Since the petitioner's claim for a petitioner has challenged the selection process for the selection undertaken for the post of assistant accounts officer, the direction of this court to keep one post vacant will meet the requirements, will safeguard the interest of the petitioner. Stop. Under such circumstances, under such circumstances, we do not think at this stage the respondents 5, 6, 7, 8 need to be arrayed as parties, respondents, in view of the statements made by the learned counsels for the respondents 3 and 4 regarding the availability, sufficient number of availability of posts of assistant accounts officer in APGCL. Also, in that view of the matter, the IA stands disposed of as directed above. One post of assistant accounts officer in APGCL shall not be filled up until further orders or till the disposal of 7448 of 2019. IA accordingly stands disposed of in terms of the above.
Lordship, I kindly record that we may have the liberty, but without leave, we will not fill up.
Yes.
Even if they decide.
What is
Because-
the use of your liberty if we don't give you?
That is already
Leave.
there.
We have mentioned it that not until the disposal of the writ petition.
Lord, provided the petitioner succeeds in this case. Lord,
Exactly,
Lordship,
till disposal,
Lordship.
till disposal.
But if they want to initiate a selection process.
One post you keep it vacant. We are not mentioning anything about other posts. Just one post. Because there's only one petitioner. In WPC 7448, you're right, in view of the order passed in IA number so and so, matter be listed for admission on a date to be fixed by the registry and as directed in and as ordered in IA so and so, one post of assistant accounts officer in the APGCL shall be kept vacant till disposal of the writ petition. Who's there? Item 3. That's
This one. This one.
none appears for the petitioner on call. Mr. J.K. Goswami appears for the respondents. List next week. List next week.
If I am for 1 and 3.
Mr. Hendy appears for respondents 1 and 3.
My senior had to leave the court because he was unwell, Lordship. So since the man is retiring this month, Lordship, on 38th, can it be taken up on Tuesday if possible, Lordship? It will departmental.
You are challenging what?
Lordship, I was imposed penalty of Lordship, 3 increments were.
Lordship, the order is at page number 39 of the reputation. Lordship, the allegation charge against his is that he has registered 15 number of cell dates below the government value, Lordship. So accordingly, which amounted to a loss of around 28 lakhs to the government. So accordingly, Lordship, it has been decided to curb some of his pecuniary benefits by keeping the petitioner under suspension. So that part he has been challenged. We have filed one affidavit, Lordship, along with the Revenue Department also filed one affidavit.
All right, then we'll take it up for hearing.
On Tuesday.
Not Tuesday. Give a date. It is submitted by Mr. Counsel for the petitioner that the matter requires some hearing. And in the arguing counsel is not available in court today. Therefore, praise for accommodation. List accordingly. Again, on so and so, Mr. CKS Purva appears for the respondent.
This man is retiring on 30th of this month. So an early date if possible maybe.
What can we do? This is a matter of 2015.
I am praying for an early date. Lordship.
No, are we giving you an early date as per our calendar? We are ready to take up the matter today. You argue the matter, we'll hear you.
Lordship, it has come to my knowledge from my learned brother and from him also that the petitioner has filed another one case on the same subject matter pending on it.
Suspension or select.
Suspension or select. That one is disposed of.
We are ready to take up the matter today.
I know, Lordship, but since my senior.
So don't cry about men retiring on so and so.
No, Lordship, that aspect also Lordship will have to consider.
We are alive to this. That is what we are saying, that you argue the matter, we'll take it up just now. We are ready to hear you.
Lordship. But my senior will argue, Lordship.
So therefore, 21st.
That's why I'm praying for adjournment. My senior is out of state.
You should argue matters. When will you argue matters? Your senior is not here. You take the opportunity to argue matters. What are these matters?
My lord, we are working in the personnel post, my lord, pursuant to our regularization as a my lord master role worker, my lord. Now we are seeking promotions as my lord other similarly situated persons has already been.
But there is a division bench judgment against
My
it.
lord, my
Then
lord, that, my lord, let them file an affidavit, my lord.
what affidavit?
My lord, we'll try to satisfy my lord, that because they are saying, my lord, that we have not been encadred. So, my lord, if.
That's what I'm
My
saying.
lord,
There is
my-
a division bench judgment of this court
Yes, yes,
where it
yes.
says that you have no right
No, right, yes. my lord,
from a
that's-
personal post.
My lord, my lord.
Unless you are able to distinguish that
Yes,
the
Mr.
division bench judgment did not consider certain vital
My
facts, it is covered.
my lord, that's
So we can make it easier for you. We'll cover it up. You go and urge the matter before the division bench,
my lord may fix in another date, my lord, on that day, my lord.
just to cover it up.
My lord, today actually, my lord, I am not fully prepared, my lord. That is my lord.
What is there to prepare? Your matter is covered by division
My lord,
bench.
certain other issues are there, my lord. In this petition, my lord, similarly situated persons who were already being, my lord.
Negative
regularized.
equality will not apply
My
to
lord,
you.
my lord, that I can understand, my lord,
Then-
but the my lord, same batch, my lord, same persons, my lord.
That's what I'm
My
saying. We can direct those persons, their cases be scrutinized.
They are not found eligible, my lord.
If they are
can
not
be-
found eligible, if that makes you happy. But
No, no, my lord, we are not
uh,
for those persons, my lord, that they should be dragged down, my lord.
so we dispose these writ petitions. You go and re-urge the matter before
My
the.
lord, may fix it on next Tuesday, my lord.
What is there to fix?
Something to, my lord, to satisfy my lord, if I can, my lord.
There's no question of satisfying. We are bound by the division bench
That
order.
is correct, my lord. If we can distinguish, my lord, if we can distinguish. I have not done for the judgment as a whole, my lord.
It's a
I'll-
short judgment.
My lord, I know, my lord. I will, my lord, next Tuesday.
We close it. That's the best thing to do. You go and urge before the division
Fine.
bench.
I can understand, my lord, but on next Tuesday, my lord, maybe please to close it, my lord. Kindly, my lord.
Where to date other detail. A joint request matter stands adjourned.
No, my lord, I am only for item 36. My friends are with other matters, my lord.
I'm in item 32, you know. And we're preparing for 33. 35.
So many councils, you are not ready to argue the matter.
Your lordship, I'm led by senior advocate Dida,
We know
but I think they were seeking time. So your lordship, short date, next date we'll argue.
what is there to argue. That's what I'm saying. It is a division bench matter. It is covered. Unless you want to say that these issues were not taken up before the division bench and therefore, or there was some other
My-
judgment
That's my lord.
which was holding the field, not considered.
Let
Well-
it be in presence of the senior advocate. Your lordship. That's a short date.
We'll record their presence if it pleases you.
I think.
Yes. 14th, based on 14th.
My lord. Oblige, my lord.
And joint request, matter stands adjourned till 14th.
Leading concern, leading Mr. Yukanari is not feeling well. Kindly adjourn the matter for today.
Now, the request of Mr. So-and-so matter stands adjourned, and as it is submitted that the arguing counsel is unwell. Mr. J.K. Goswami appears for the respondent state. Adjourned.
Question made before 10th of September, 12th of September.
It will come as and when it comes, it comes.
So kindly
No, we can't fix all matters. If the matters are fixed, then it is required to be argued. What is the point in fixing a matter if the matters are not argued? It will come on some date.
kindly matter illness dismissal from service.
That's right. So it will come at the end of September, maybe. Some date.
14th of
Not 14, not 14. We have already fixed matters on 14. You take a date from the court. Yes.
My lord, this matter relates to unauthorized absence from service.
Hmm.
And on earlier occasion, Lordship here heard this matter, and we were relying to the decision of Honorable Apex Court in Parmar case, my lord. Willful.
This is a matter which was remanded by the division bench.
Yes, my lord. And
That willful absence.
yes, that must be proved
Proved.
by the inquiry officer, before the inquiry officer. Here, my lord, on going through the inquiry report, it is not found. And rather, it was found that the reasons of his absence he spelled out along with the other witnesses, witness number 1, 2, and 3, page 38, my lord, of the writ petition, and page 39 from the inquiry report, my lord.
This was substantially heard. What was
Yes,
left?
yes.
What was left?
And the last occasion, my lord, directed to give one, my lord, list of dates.
Yes,
I have given, my lord, on last occasion, my lord.
yes.
Yes. My lord, here, my
Anything
lord, the
more?
petitioner reported back in duty on serial number 8, my lord, from the list of dates 1/7/2011.
You want to say that he was not,
Willful act is not there on his part.
what do you say? What is the term used?
Uh, Unauthorized absence may be there, my lord.
Deserter. He was not a
Yes.
deserter.
Not a deserter. I came back on 1/7/2011 of my own, my lord. So,
Yes.
Now, Lordship, my learned friend's contention was, I'll just start from the beginning, Lordship. In the first round of litigation, Lordship, he was not on the disciplinary proceeding, he was
I
only
was.
on the medical part, which I would reiterate, and that is amply reflected by an order passed by this court on 9/11/2021, pursuant to which he had also filed an affidavit. Now, that was his course of argument before the learned single judge at that point of time. Of course, he made a shift before the division bench.
No, but you are not in appeal.
Now, since it has been remanded back now, Lordship, let us see. He is on willful absence, whether willful absence has been proved or not. Let us see the charge first. Page 31.
Yes.
Page 31. Dada said so and so of C5 Battalion CRPF while functioning as so and so Mahavir Nagar campus, New Delhi, has committed an act of misconduct in his capacity as a member of the force under section 11(1) of the CRPF Act, and in that he deserted from the company lines on 14/10/2010 at about 1700 hours and still absconding without any information or any prior permission of the competent authority, which is prejudicial to good order and discipline of the force. Now, this was issued on 18th of April 2011, and he was deserting or absconding from 14/10/2010. If I may take your lordship to Rule 31 of the CRPF Act.
CRPF.
He says he has come back on his own volition. Whether that saves him?
Rule 13.
In my book, it's page 32.
Three zero 31 13
31.
31. No. Rule.
Rule 31, page
31.
32.
Okay.
Desertion and absence without leave. If a member of the force who becomes liable for trial under clause 5 of section 9 or clause M of section 10, or for deserting the force while not on active duty under clause P of section 10, read with clause F of section 9, does not return of his own free will or is not apprehended within 60 days. of the commencement of the desertion, absence or overstay of leave, then the commandant shall assemble a court of inquiry consisting of at least one gazetted officer and two other members who shall be either superior or subordinate officers to inquire into the desertion, absence or overstay of leave of the offender and such other matters as may be brought before them. Now, if he had reported back within those 60 days, maybe he would not have been a deserter. When did he report back? Lordship will see
No, is it,
from his,
does not return of his own free will?
does not
One-
return of his free will, or he is arrested, apprehended, sorry.
Does not return on his own free will.
It is, Lordship, the word is, does not return of
Of
his own free will, of his own free will,
Right.
or is not apprehended within 60 days.
Now this 60 days, is it to be applied to both or is only for the arrest part? Does not return on his own.
If he
free
does
will.
not return of his own, then
Free will.
also there will be a court of inquiry. Or if he is arrested, apprehended, brought, then also there will be a court of inquiry. Now, when does he return? From 14/10/2010, he was not there. And in the list of dates, Lordship will find, he reported back on 1/7/2011.
No, see. Section Rule 31 says two situations. Number one, he does not return of his own free will,
Yes,
in which case he has to be arrested and brought back. So that arrest and bringing him back, is it within 60 days? Or is it a case that, see, once a person does not return of his own free will, on his own free will, to proclaim him to be a deserter, you must know about his whereabouts, find out his whereabouts, which will require apprehending this man and bringing him back. In his case, no such step was taken by the
the
authorities.
apprehension roll was issued.
No, but he was not arrested.
He could not be arrested.
Then he comes back.
Then he comes back after
So
1
he
year.
does
he
not,
gets out.
so if he comes back,
In
he
the
does not.
meantime, Lordship, there was a court of inquiry.
Hmm.
In the meantime, there was a court of inquiry. He was declared a deserter.
No, that's what I'm saying. To declare him to be a deserter,
Yes, Lord. There has to be a court of inquiry.
no, there has to be first, you have to ascertain where this person is, because he has left the unit and gone. If it is a case that the moment he leaves and goes, you are entitled to declare him as a deserter, then this requirement under 31 will be, some meaning will have to be given to 31. So 31 says,
Lordship.
if the person does not return on his own free will, and then he is arrested, apprehended, and brought back,
No, Lordship, I beg to differ, Lordship, the language, Lordship. I take your Lordship again to the
yes.
does not return of his own free will,
Hmm.
or is not apprehended. It is not and then,
All right,
or is not apprehended within
Within
60 days
60 days.
of the commencement of the desertion, absence or overstay of leave, the commandant shall assemble a court of inquiry consisting of at least one gazetted officer and two members who shall be either superior so and so, and then there is the court of inquiry. Lordship. Now, here is a case where he turns up after 9 months, and at that point of time, the Court of inquiry is over. Now, whether to retain him in service or not to retain him in service, the disciplinary proceedings are on.
Yes.
He reports at that time for a day and is again missing.
Yes.
This is precisely the case of my learned friend. Now, the decision which my friend relies upon, Krishnakant Parmar, if I may take your lordship to the relevant paragraphs my friend was relying upon. The question whether unauthorized absence from duty amounts to failure of devotion, lordship will know, amounts to failure of devotion to duty or behavior becoming unbecoming of a government servant cannot be decided without first deciding the question whether the absence is willful or because of compelling circumstances. Now, he has to show whether his absence was not willful or was under some compelling circumstances. For that, he relies upon the medical certificate. The medical certificate, lordship will know, he is not there from 14/10/2010, and a medical certificate, lordship, is of November 2011. Whether during this period he was, lordship, under some circumstance which did not allow him to join or resume his duties. If we read further in the Supreme Court this judgment, lordship, because here the authority has to see whether it was willful or not willful. Now, if it was not willful, he has to supply some material to the authority at least for the satisfaction. If the absence is the result of compelling circumstances under which it was not possible to return or perform duty, such absence cannot be held to be willful. Now, what is that circumstance? Compelling circumstance that he was not able to return or report for his duties, that is nowhere there. Absence from duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. I'm with that. I'm fully with the Supreme Court decision, lordship. But the materials on record have to substantiate that it was not willful, either before the authority or before the squad, lordship. If he had a subsequent chance to bring the materials before the squad, it is not their lordship. Therefore, my humble submission, lordship, that his willful absence has not been proved. His unwillfulness has to be shown by him, lordship. I cannot show that. He says I was mentally unstable. Where is that certificate? The certificate is against him. The certificate submitted by him is against him. It may be a case, lordship, where he was very sincere to his duties prior to that. But this incident would not give confidence to your lordship to declare that he was sincere to his duties. Let us see point number 6 at page 38. Once again, my friend was so vehemently relying upon it. 6.
Oh.
And of the writ petition, Lordship, page 38.
Yes.
On analysis of the evidence, it is found that there is no information as to why Pankaj Bezbarua had absconded from the camp line and how. Whereas on the basis of the statement of Constable Pankaj Bezbarua, it is learned that he did not know anything as to what had happened to him. Due to his mental stress, illness, he absconded. This statement that due to his mental stress, illness, he absconded is not substantiated by any medical document, Lordship. But he has proved that he has suffered from mental illness or stress. That is his statement before the inquiry officer. During his disappearance, he did not make any communication with the company or the force. And though he appeared before the investigation officer at the preliminary stage of investigation after he had been served notice to that effect, but on 19/7/2011, he again absconded. He appears and he again absconds.
This page number 37
Uh,
is what? Is the inquiry report
Yes.
of the DP.
Yes.
Now, is this a proceeding under Rule 31?
This is not the Rule 31 is only for the court of inquiry, Lordship.
That's right.
Court of inquiry is there, Lordship. I
So,
have the record with me.
Rule 31 is the procedure prescribed to find out whether he is deserted or not.
That is there, Lordship.
So, where is the finding of conducted by the officer under Rule 31?
If I may refer your Lordship to page 24 of my affidavit, Lordship.
Here.
The court of inquiry was constituted by NHSC. And if your Lordship will come to page 26, it had submitted its report on the fourth line, page 26, on 29/1/2010.
Yes.
And he was declared a deserter, Lordship. Thereafter, the disciplinary proceedings, Lordship, initiated on 18th of April 2011, Lordship. That is Annex 9 to the writ petition.
Yes. Yes.
And the report I was just referring to, Lordship,
I was reading point number 6 at page 38 of the repetition.
Yes. This court of inquiry finding, was it challenged? No.
No, man. Because everything is against the behind my back, my lord. My lord, my lord, no notice of court of inquiry was ever received. So only the order, the my lord, whereby.
When did you receive it?
My lord, in fact, he filed RTI, my lord. He filed RTI, my lord. And the delay for filing the writ petition, my lord, as well as the appeal before the appellate authority, we given the grounds for continuation of delay, my lord. In the my lord, appeal, departmental appeal, as well as in the writ petition, my lord.
No,
My lord, elected
The
person
departmental
suffering from-
appeal is against the departmental proceedings.
Yes, my lord. Yes,
These findings of the court of inquiry,
my lord.
where you have been declared to be
Deserted.
deserter,
Yes.
that has not been
That is
challenged
not
anywhere.
But yes, in the writ petition, I have challenged this order also. But stating thereby that, my lord, the entire proceeding behind my back and no inquiry report, nothing was forwarded to the petitioner as per the judgment of my lord Ramzan Khan, my lord. Any inquiry conducted, the inquiry report is to be furnished. Here in the department, I'm sorry, my lord, the court of inquiry proceeding, my lord, whereby I was declared deserter, my lord, nothing was my lord, forwarded. Moreover, our ground is that page 39 of the writ petition, page 39 it is clearly provides, it appears, sorry, page 49 of the writ petition. My lord, this is para 5 in between, this is very important, my lord. Para 5 middle portion. Therefore, page 49, my lord, para 5. 6th line, my lord. Therefore, after taking into consideration all aspects of this case, I am of the opinion that the delinquent numbers of Pankaj Besbros is deserted from line unit on so and he reported back. Malad, this is important, Malad. Para 5, Malad, middle 6th line from of the para, Malad, top, Malad. Yeah, para starting with, Malad, I may read the entire para, Malad, para 5. Before taking any action on the report of inquiry officer, a copy of inquiry officer was forwarded to the delinquent at his known home address by registered post. So with a direction to submit his representation against the report, even with 15 days of receipt of the report. The delinquent has not submitted any representation till date. Therefore, after taking into consideration all aspects of the case, I am of the opinion that the delinquent was Pankaj Besbora deserted from line unit on 14/10/2010 at about 17 hours and he reported back, my lord, at his own on 1/7/2011 and again deserted from following line on 19/7/2011. My lord, my endeavor is that, my lord, so far they have said, my lord, to my own address, they have forwarded the report and all, my lord. If they know my address, my lord, and if they came to believe that I was on my address, my lord, no endeavor has been made to arrest me. I, of my own, my lord, I appeared. I went back to my office, my lord, 1/7/2011. And they allowed me to continue there up to 19/7/2011. And thereafter, they have not allowed me, my lord. I have to come out from the office.
I
Moreover,
dispute
no,
that,
no,
Lord.
that's
How
correct.
can he say
No,
we
no,
have
no.
not allowed?
No, 19/7. This is
No, you have absconded. Our stand is you have absconded.
no,
No,
okay.
where
fine.
is the lordship
No, from-
statement in the writ petition that we have not allowed him to stay?
No, sir, from your own document, I am reading.
Is
So
there any
therefore, let me.
punishment prescribed for a deserter?
This is the lordship.
So for deserter is concerned, my lord, if person is declared as deserter, my lord, as per 31C, my lord, this is very important. In desertion, my lord, but he shall not thereby cease to belong to the force. Even if there is a desertion, I will be treated as in the force until and unless my service is terminated under section 27. And this is the, my lord, inquiry
That is
for
what has been done,
termination of service.
Lordship.
So 31C is very important, my lord. 31C, my lord. The commandant shall then publish in the force order the finding of the court of inquiry, and the absentee shall be declared as deserter from the force from the date of his illegal absence, but he shall not thereby cease to belong to the force. This shall, however, be no bar to enlisting another man in place of a deserter. But my lord,
If I may for a moment, Lordship, draw your attention to
let it
section.
complete.
No,
Yes,
please
please.
on desertion, Lordship had asked me, put me a query.
Yes.
9F, Lordship, relates to desertion. Section 9F
Deserts the force.
shall be punishable with, this is transportation of for life for a term of less than 7 years or with imprisonment, so and so, fine to that extent.
But termination is not a prescribed.
Termination, Lordship will find 11, though this, I find that the charge, I was just reading the charge. Under, at page 31. It was under section 11(1). 11(1), if I may read, Lordship. The commandant or any other authority or officer as may be prescribed may, subject to any rules made under this act, award in lieu of or in addition to suspension or dismissal any one or more of the following punishments.
These are minor punishments.
Yes,
These,
minor.
Lordship, though it starts as a minor punishment, these are in lieu of. Lordship will find made under this act, award in lieu of or in addition to. Therefore, a punishment of removal is contemplated under section 11. That has been
Under Rule
upheld.
26.
That has been upheld by the Supreme Court in the case of Ghulam Muhammad Bhatt.
You're referring to 11(1)(e).
Yes.
No, Lordship, if I may, I am reading the opening part of the section, Lordship. The commandant or any other authority or officer as may be prescribed may, subject to any rules made under this act, award in lieu of or in addition to suspension or dismissal any one or more of the following punishments. That means the authority has the power of dismissal under section 11(1).
this A, B, C, D, E can be added in lieu of or in addition to. Now my submission before your lordship would be he has been declared a deserter under Rule 31, complying with the provisions of Rule 31. Thereafter, a DP has contemplated under Section 27 has proceeded. In the departmental proceeding, he appears, though he says for a few days. He could have well taken his defense. What he comes up with is only a medical certificate where the medical authority says that there is no disorder with him. Will that amount to unwillful absence? That cannot be termed as unwillful for something that he could not report back to his duties. The medical certificate would not support him in that. Therefore, it has to be presumed that his absence was willful, lordship. Had it been otherwise, lordship, he would not have reported back and he would not have further absconded. He would have continued at least with the inquiry, lordship. Lordship will take note of that also. Therefore, the judgment rendered by the Honorable Supreme
With the hearing.
Lordship.
Thursday,
कितने देखो
14th.
Lordship.
Some difficulty on this side today. We'll take it up on 14th. No. Yes,
Well, the petitioners hereof are retired and senior meter reader of the APDCL, my lord. They are basically agreed, my lord, for not for withdrawing their benefit granted MSCPS benefit, my lord, withdrawal. That is why they are agreed. Whatever, my lord, the last communication, I'm taking my lordship WBC number 7109.
7109.
7109.
seven one zero nine.
Yes.
Yes.
My lord, last page is the impugn communication that is given to the petitioner. May I read, my lord?
We'll take it up next week, these matters. Fix a date.
So, lord, may I kindly give a date?
Take a date from you. Not feeling too well today.